Board of Architects and Engineers Examiners are meeting today in room 1, whatever, Davy Crockett, in regular scheduled meeting. Is here. I think we're ready to go. I'm waiting on Mr. Cawthorn. All right. Ready? I don't have my cheat sheet, so I'm going to do it by fake. I'm going to memory fake it here. First of all, I'd like to welcome everybody to the August meeting of the, from here on out for this rest of the year, the Engineers and Architects Board. Did y'all catch that?
Yeah.
Oh, yeah.
At its regularly scheduled meeting in room 1A of the Davy Crockett building.
And the agenda was posted on the board website.
And the agenda was posted on the board
August
website.
4th.
August the 4th. So I think that makes us legal. So, Ms. Garner, if you don't mind, will you proceed with a roll call?
Susan Ballard.
Here.
Hal Balthrop.
Here.
Robert Campbell.
Present.
Jerry Headley.
Present.
Philip Lim.
Yeah.
Bill Lockwood.
Here.
Rick Thompson.
Here.
Frank Waxter.
Here.
Ricky Bersai.
Here.
Stephen King.
Here.
Laura Reinbold.
Present.
You have a quorum.
Thank you, ma'am. Now I'd like to acknowledge our guests, and I see some familiar faces and some not so, especially the one in the sunglasses in the back. Go ahead and introduce yourselves, please. Thank you very much. Any announcements? John, do you know of anything?
I do have one announcement to make that Robert Campbell, Ricky Bersai, and Frank Waxter have all been reappointed to the board, we've heard. And that they're going to serve through June 30th, 2019. So that's the only announcement that I have.
Probably another sign of the impending apocalypse, but we'll get over that. You don't need to tell us about exits from the building or anything along those lines? Okay, fantastic. Anybody from the board have any announcements? Nothing? Okay, great. We'll go on then. Has everybody had a chance to review the agenda? Are there any changes or modifications that need to be made? Yes, sir.
Oh, just one item to add. We need to vote to approve an emeritus certificate for Mr. Borden, who's, of course, rotated off the board. So you could just
Hey,
add that at any
Can we go ahead and do that at this time?
That'd be
Okay.
fine.
Second.
All in favor?
Aye.
Thank you very much, and it passes. No changes, seeing none or hearing none, we'll go ahead and have the agenda as printed. All right, now we go to our consent agenda, and John, if you don't mind, can you also let us know where this is on our iPads, please? It's the minutes from the board meeting, I believe is the first part of that.
Right, that begins on page 87 on your iPads. Minutes from the June 2015 board meeting for your review and approval.
I have one correction.
Okay?
Page 92, under unfinished business, item C. The state fee schedule still is something we'd like to pursue until we can get documentation from interior designers in the field. Is this on hold? It is necessary. So if we could strike that where it says no longer necessary, it is basically on hold, so.
Excuse me.
Any other changes to the minutes as printed? Okay.
I would move to approve the minutes as noted with the revisions.
Second.
Any other discussion? All in favor say aye.
Aye.
Okay, John, I think you have the staff complaint reports next.
But that's on page 104 on your iPads. These are all complaints in which the respondent was disciplined in another state. The discipline was less than a suspension or revocation, and recommend closure in accordance with board policy. You can just vote on these as a group.
Second.
Questions? Discussion? All in favor say aye.
Aye.
Opposed? And the ayes have it. Okay, it's now, nothing else on the complaint report, correct? Now we go to professional societies. Actually, let's start with you. We'll go left to right since I'm left-handed. And it made it harder for you to get out of the aisle there, so.
Hello, it's on. Okay. This is Ashley Cates with A&E Tennessee. I'm the Executive Vice President. So I wasn't here in June. I'm sorry to miss that meeting. Talked with John. I don't think I have any tasks left. I wanted to give you an update since the April meeting. I know you all were aware that ACEC and A&E Tennessee have been working with the state architect on the state contract revisions. We concluded our negotiations in May, the middle of May, and we have yet to hear from the state on where to go from there. We developed a white paper. I'll kind of give you a little history of it to tell you, since a member actually did it for me. A lot of this was before I came here. It says, for many years, A&E Tennessee, in conjunction with ACEC, has worked closely with the Office of the State Architect to periodically review and negotiate contract terms for state projects in accordance with SBC policy. Our window for this negotiation opened approximately in 2006 and was postponed due to the economic downturn. These negotiations have been ongoing now since 2012 with no implementation of various recommendations. Clearly, I won't talk about that in a moment. For this contract negotiation, the state approached us with a two-part process. The first phase was to be general contract language review, and the second phase would work through scope and fee. Unfortunately, the first phase morphed into a review of the scope and basic services, and over our projections, left out the fee negotiations. We have since proposed a fee increase and are receiving heavy pushback from the state institutions. So you all know the current formula. What we believe is we proposed a new fee formula with a logarithmic formula in addition to complexity multipliers to cover the complex building scopes and include some but not all the necessary specialized consultants. The proposed fee adjustment represents an increase in the cost of doing business as well as the additional requirements being placed on us contractually by the state, including higher insurance requirements, no travel expense reimbursement, and basic service required beyond those in the private sector. The fee adjustment also represents what is needed to reflect the rate of inflation since our last fee adjustment. This negotiation is of paramount importance, and even if our members do not do state work, as many do not, they work with other government agencies and private sector clients, and they use this fee as a basis for negotiating their fees. So essentially what's happened is we've given this contract to the state architect, and we're waiting to hear back from him. So I'm sorry, I cannot report anymore. We're reaching out to TBR and UT on several we've already reached out to TBR on several RFPs that have tried to include additional services in their basic services. And we're setting up a meeting with UT most recently, the Lake Avenue Garage RFP. They tried to place additional services into basic services. So we're continuing to try to work on that to make sure that there is education involved when, working with designers of what is basic and what is additional. So unfortunately, that's all I have to report to you about the state contract revisions. I'll keep you in the loop as we move forward. Some good news is we had our convention at the end of July, and we're starting to recognize our new licensees. And so from last June to this, I guess from June 2014 to June 2015, I think we had 35 newly licensed architects in the state. And I want to thank John. He helped us pull those numbers. And the architects, we're making a really big push now at our President's Luncheon to acknowledge them. And there is an architect in Knoxville that has I guess, produced and designed a wonderful award that everybody loved. And I wish I had brought an example. So I'll bring one to the October meeting to show y'all. But everybody was excited, and the foundation, the Tennessee Architecture Foundation, provided complimentary registrations to these new licensees so they could attend a convention for free. So other than that, we're gearing up. We're going to start looking at legislation, anything for it's going to come up in 2016. If anyone has any questions, I can answer them now.
Questions for Ashley? Thank you very much. Don, please, and you're next.
Good afternoon. I'm Don Baltimore with the Tennessee Interior Design Coalition, and I want to congratulate all of the board members who were reappointed and look forward to continue working with you. I really don't have anything to report other than that we'll be having one of our coalition members, American Society of Interior Designers, will be having a state convention in October in Nashville. And then as far as legislation, we have none that we are looking at passing or introducing. We will be working with the board and the architects and engineers and landscape architects for any legislation that affects our industries. Thank you.
Very much. Any questions for Don? Ford? Okay, thank you very much. Casey?
I have a few things to report. I'm Casey Anderson with the American Council of Engineering Companies of Tennessee and the Tennessee Society of Professional Engineers. Couple of things are going on. As Ashley mentioned, we are still waiting for some resolution on the state contract, and that's been it's been a good partnership between the architects and the engineers working on that, but it has been we've been frustrated with that process, as you all know. Yesterday, the TSP and ACEC sent a joint letter to both the members of the Memphis City Council and the Shelby County Commission because they've got a joint ordinance they are considering that weakens some of the international residential codes. So that will come up in the next week or so for them. So we've commented on that this week. We have been vigilant in addressing a bunch of QBS concerns since the last meeting, just different issues that have come up, and they're coming a little bit from everywhere. And I just want to thank John. He's been really helpful in talking through those with me, and I know we all get a lot of those calls, and I think together we're working really hard to make sure everybody's educated on the appropriate use of that before putting out an RFP or an RFQ. Two things that I want to make a formal comment on behalf of our associations. In next 2 weeks from now is the NCWS meeting in Next week is the NCWS meeting in Williamsburg. TSPE and along with them NSPE, which is the National Society of Professional Engineers, want to go on record with you all in letting you know that they are opposed to the proposed changes in the structural specific licensure in any form at this point, the way that they are proposed at that meeting, the language that we have seen. And there were two sides of that. One is an additional licensure, and the second is that we saw in one of the amendments was an SE licensure in lieu of the PE. And so they just wanted to make sure that you all were fully informed that both of those groups, TSPE and NSPE, are opposed to those measures. You all asked at the last meeting for me to take decoupling back to the two boards of engineers of the association boards. The engineers are still a little bit divided on this one. They would prefer that we take some time to discuss the issue without pressing forward for this year's session. The feeling is that the issue needs significantly more vetting, and any proposed legislation would ideally address the experience and education issues that many of our members feel. At this point, if it has to go this year, they would prefer that it comes back to you all and goes through the governor's package versus the associations carrying that legislation. Two other things. Engineers Conference, September 17th and 18th. Hal is going to be speaking at the luncheon this year. Hopefully that will be have a great attendance because we have moved you away from any other opportunity for a PDH. So you are it for that session, and following that will be the Transportation Working Group. So you will have, I would assume, a fairly large audience for that. The second thing is that we are offering a PE exam review for the civil exam that is in October. So if you all have anybody who might be interested in taking that, please let me know. Questions?
Patty? Anything? Thank you very much, and you will stick around for the recessed engineer meeting?
Absolutely.
Okay, after this, thank you.
Thanks.
Okay, my late arrival, Mr. Ridley, and please introduce yourself for the record.
Good afternoon, Mr. Chair, members. Nathan Ridley on behalf of the Tennessee chapter of the American Society of Landscape Architects. Here at the local level, we've just gone through, as Hal and Bill and Laura know, a metropolitan Nashville-Davidson County election for our mayor and our council, but we also had 3 charter amendments, and the only one to pass had to deal with the design and built environment. And the practical effect of that would be for any public project, 40% of the labor has to be from Nashville. And it sounds like a great idea, and that's probably why it passed, but the implementation of that will be difficult, not so much for the design, but to a certain extent it will affect the design community because the folks who build the things, my concern is, and for our chapter was, it's going to take longer and cost more. But I think sometimes when you're running an electoral campaign, if you're trying to oppose a proposition that's hire local or hire Nashvillians, that's hard to combat, because I'm a lawyer. It takes me a lot of words to wrap around it because I say I want to hire the best carpenter in Middle Tennessee, and she lives in Gallatin. But she's not going to satisfy my higher local quota. So the implementation of that and the local officials, I think the present administration are sensitive to it. It'll be interesting to see how that works out. We'll also have, as y'all know, a runoff election because you have to get a majority of the votes cast in your election. So we had so much fun with the August election. We're going to have a runoff on September the 10th. And our annual meeting will be here in Nashville, and I believe it October this year here at Vanderbilt, or part of it will conflict. And that's all I have to report. Happy to respond to your comments or questions.
Okay.
Thank y'all.
Thank you, Nathan. Okay, that concludes our professional society reports. Eldery, you're up with the legal case report, please.
That's on page 105 on your iPad.
This thing won't get any closer, so excuse me. Case number 1 is case number 2015-007201. Respondent was hired by an insurance company to perform a storm damage evaluation on a residential roof. Respondent's report finds that the roof damage is due to poor installation and not wind and hail damage. Homeowner files the complaint against respondent, alleging incompetence for that report due to not having a roof contracting license, unauthorized practice of law for relying on a residential code section, and unprofessional conduct for writing what the insurance company wanted instead of using his own professional judgment. Respondent states that he has performed storm damage evaluations for 25 years. He always uses his own professional judgment. Engineers, of course, read and interpret code sections to do their jobs, and that the complainant has not shown any proof of incompetence. The complaint does not show evidence of unprofessional conduct or unauthorized practice of law. My recommendation would be to adopt the reviewer's recommendation, which I believe was also to close the complaint. And Robert Campbell did that review.
It's not on 105, is it?
No.
It's actually 109.
Okay.
Yeah.
Oh,
I was going by the number on the agenda.
Sorry, I started
Page 109.
I started trying to keep up, and the first 2 sentences were similar, and then I thought, well, crap, my eyes were
The
worse than I
page
thought.
105 is a legal opinion.
All right, any questions? I'll be glad to answer them, since I'm the reviewer, I suppose.
I would move to adopt the reviewer's recommendation.
second.
To close.
Any discussion? Seeing none, all in favor say aye.
Aye.
Opposed? It passes.
Right. The next case is case number 2015-004461. This complaint is based on Rule 0120-2-.04, which states that the registrant shall be completely objective and truthful in all professional reports, statements, and testimony, and Rule 0120-2-.02, which states that if the registrant becomes aware of a decision by his employer which adversely affects the safety of the public, the registrant is required to speak out to the point of resigning. Complainant asks that the board decide whether respondent's claims of his employer's law-breaking are truthful. Respondent alleges that his employer does not allow employees investigating accidents to report any professional misconduct that may have caused the accident to professional boards. Respondent also alleges that it does not give independently contracting employees the ability to speak out against safety violations contrary to the law. These issues are in pending litigation. My recommendation is that the respondent ask the board to determine whether he is truthful in his claims, but these issues are pending in litigation, and it appears that a judge may soon decide whether the employer's actions are unlawful and creating a safety concern, which I believe is to be the appropriate action in this matter. Therefore, I recommend closure.
Moved. Second? Second. Any discussion, questions? Seeing none, all in favor, say aye.
Aye.
Opposed? We go ahead and close it then. Thank you.
Right, the next two cases are separate individuals, but it's basically the same issue, and it's all tied to the same case. It's case number 2015-011371 and 2015-011381. Complaint is filed by a homeowner who is suing a state agency for alleged damage from vibrations due to construction. The complaints are against two engineers whom the Attorney General's office, who is representing the agency in the lawsuit, has retained as expert witnesses. Complainant states that their expert witness reports demonstrate incompetence. Respondents state that the Attorney General's office asked them to investigate the complaint, and they are serving in the capacity of expert witnesses in the litigation. My recommendation is, since the respondents are serving in the capacity of expert witnesses in a civil suit, recommendation is closure, as the lawsuit will determine whether complainant's allegations are accurate. And I just have a personal opinion that I'm concerned about filing complaints against expert witnesses, the chilling effect it might have if parties to a lawsuit are allowed to just file professional complaints because they disagree with the reports. So that's my personal opinion as well, but the reason I'm recommending closure.
Second.
Any discussion?
So, just to get it clear, your concern is about other professionals filing a complaint against the expert witness professionals?
The complainant, who is also the complainant in the civil suit, is filing complaints against, apologize. He's filing professional complaints against the opposing party's expert witnesses. And the point of expert witnesses are to give their professional opinions in a courtroom setting to determine what the issue was when you get multiple expert witnesses, to determine whether there were actually incompetence that caused this issue or not.
It's the homeowner.
Right. The homeowner is filing suit against the state agency for what he believes was damage to his home. And as part of that suit, or stemming from that suit, he's filed these professional complaints against the engineers the Attorney General's office has contracted with to be expert witnesses in that litigation.
So he's filed, or the homeowner has filed a complaint with this board?
Yes.
Okay.
Against the reports those engineers did for the litigation.
Well, I understand your concern, but we can't regulate who files a complaint. I mean,
Right.
I can file a complaint against Robert if I want to. I mean, it might be unfounded, but it would be, that's their prerogative. So, but we will review them and know whether they're legitimate or not.
If the
If
board
they get-
wishes to review them, they can. It just seemed to me that since that is the issue that the civil suit will decide,
Yeah.
that these were not stamped plans submitted for construction, that it just didn't seem necessary. But if the board wishes to go forward and review them, they can. I just wanted to present that first issue as I saw as a potential concern.
And I don't disagree with your comment, but I think what I'm interpreting from the recommendation is that we're trying to protect the integrity of the expert witness process. And until there's, a decision in the court to know whether there's validity in the lawsuit, then maybe there's consideration for malpractice. But again, in this case, it didn't involve any sealing or anything that's under the jurisdiction of this board, because they're just expert witnesses making testimony. They're not actually performing, design services that affect public health and safety.
And I don't disagree with your statement. I'm just saying that anybody can file a complaint.
Yes.
I mean, if they're going to be vindictive about something, they can do it.
Yeah.
And whether we review it or not is another question. I'm just making a statement. Because I certainly wouldn't want to be testifying against or for someone and then someone file a complaint against me. It would be unfounded, but.
Let me, even though not necessarily supposed to weigh in, but let me make a couple quick comments. First of all, I think the Attorney General here has kind of put the engineers in a little bad position. I mean, to investigate and then be the expert witness seems to me you ought to have two separate groups that would do that to kind of maintain that firewall a little bit. Again, just seems to me to be a little different. We typically have people that investigate. I think tomorrow we have a hearing where some people on our board have investigated, and then we've called expert witnesses to say whether that's right, wrong, or indifferent. So I think to have the same people investigate as well as be expert witnesses, to me seems it'll be a little hokey. And I would agree with Rick that on some level we probably ought to take at least a cursory look to see. And I understand we don't want to, but ultimately the judge makes a determination whether they're expert witnesses or not. Correct?
Right. They have to get certified for a full trial hearing in court. They have to be certified as expert witnesses, and in that hearing, the judge hears arguments for and against their competency and expertise, experience, education. Then they are certified as competent enough to be the expert witness. They are considered an expert.
Is that with the agreement of both parties, the legal counsel of both parties?
The judge will make the final determination whether.
The point is, it's outside the attorney general nominated.
Right.
But they weren't the final decision that they would testify.
Right, the judge still has to, the opposing party can attack is kind of a strong word, but say they're not qualified enough to be expert witnesses, and then if the opposing party challenges it, it goes to this hearing.
Questions?
Let the judge decide.
Well, I mean,
Yeah.
at the end of the day, I think whatever this board does, the judge will decide whether they are expert witnesses or not, and ultimately it will be adjudicated or thrown out, based on, since it is at a lawsuit time. So I think even our other parts of that, our hands are we're not going to be the final stop on this as well. So the judicial system. Comments? All right. All those in favor say, I think we got a motion.
In favor of what?
Of your motion to
Okay.
remove, close.
The motion, and
It's been seconded.
I thought somebody
Do a
motioned.
second. I did
It's
the
been
motion.
seconded
Yeah.
already.
second,
We just need to vote.
Need to vote. We've had questions.
my motion is to adopt our legal counsel recommendation.
A discussion, so all those in favor say aye.
Aye.
Opposed? Okay.
The last case on the complaint report is case number 2015-014-571. Respondent renewed his license online in August of 2014 and indicated that he had earned his continuing education hours. Respondent was selected for a continuing education audit in October, so 2 months later. Respondent practices in another state and has not practiced in Tennessee for several years. The continuing education does not transfer to Tennessee for the state he practices in. Respondent stated that he was inactive in Tennessee, although he had not submitted the required forms to go inactive. On June 1st, 2015, respondent stated that he could not produce the required documentation and asked for an extension. He reiterates that he has not practiced in Tennessee during this time period. In mid-July, respondent submitted the form to go on inactive status. And my recommendation is discuss, because I'm not familiar with how the board handles continuing education issues. It appears that he had not completed his continuing education, and he has not provided any proof of that. And he is now inactive, but the audit was for the prior years from before he came inactive, and he has not submitted any documentation.
Now then, but since we don't have a motion on the floor, let's go ahead and open up for discussion, and we'll come around to a
Make a
motion.
motion that we open for discussion.
Oh, sorry,
No.
just to add one thing. Francis completed a
I think I get to let
timeline
you do
of how all this came about, if any of y'all want to look at it.
Can I ask a clarifying question?
Second.
Sure.
He was first.
Well, I may be asking the same question. Does Tennessee, I thought Tennessee recognized, well, is this,
If he's in,
I ask, I thought,
Engineering.
I thought in Tennessee, we accepted the
we do for most states, but there are certain requirements that have to be met in order for us to recognize that. And this state, I think they are in the process of meeting those requirements, but at the time, we did not recognize continuing education from there.
Yeah, well, my understanding is their continuing education was not, their rule was not in effect for the period in question. It's not mandatory in that
otherwise
state.
we would if we
Right.
had.
Yeah,
All right,
usually
just-
we would, but in
thank
this
you.
particular case, we do not.
My question was, he is currently inactive, but it was not in the
He
time.
became inactive just a few weeks ago. He submitted the affidavit.
Right.
Not, like, this had been ongoing for the past year.
And if that paperwork had been submitted.
If it had been submitted last year, or
Yeah.
before his renewal, it would have been fine. But he's now gone on to a separate cycle. So my understanding is he was active for this period that he had not completed the continuing education for.
Would it be just a simple mistake on his part that he thought that his home state continuing education credits would transfer to Tennessee? I mean, if it's not the same amount, and we have this, different states are now requiring all HSW, and some are not, and some don't even require any, which is, I don't get that.
Right. My understanding of this state, and John, you can correct me if I'm wrong, is that they didn't require any continuing education, and their rule is coming into effect or just came into effect requiring it. But during this time period, there was no requirement, and he has not submitted anything to us, much less anything that might meet some states and not ours.
So he met the local requirements, his state's requirements.
It appears so,
Okay.
yes.
Or I think I cut you off.
No, I just was trying to figure out what the issue was. The issue is that he did not become inactive quickly enough or properly?
Issue was he was actively registered and renewed his license, saying he had completed all the required continuing education. And then once he was caught with an audit, he said, "Oh, I want to go inactive."
Thank you, that clarifies.
Just to ask, were there any?
He has not presented any type of extenuating circumstances. And I believe Francis told him, months ago, if he wanted to be inactive, all he had to do was submit the affidavit. And it only just now came.
And when was he licensed in Tennessee? Initially?
I don't know the initial date.
So more than 3 or 4 years.
I'm not sure.
Okay.
Now that we have electronic files, I can't bring it down with me.
We're having a lot of questions. Would it be helpful for us to hear the timeline?
Yes. All right. August 30th, 2014, respondent renewed his PE license online, answering the question concerning his continuing education hours with a yes, indicating that he had his 24 hours of continuing education, and also answering the question regarding carryover hours as having 12 hours. On October 27th, the board office sent him a letter stating that he had been selected for an audit and to respond within 30 days. December 2nd, we sent a second notice. That letter was returned unclaimed. January 6th, we emailed the respondent, which he did receive, and January 25th, his response was to say that he'd elected to go inactive. And then the next day, Francis Smith, compliance coordinator, emailed respondent asking him when he sent in his inactive affidavit. That day, respondent emailed back saying that he had not submitted a request and wanted instructions as to how to do so. January 27th, Francis emailed the respondent the form and instructions, also advising respondent that going inactive now will not negate the continuing education audit, and he will still have to comply. We did not receive anything from him in the next 3 months. So April 21st, 2015, Francis called the respondent to ask why we had not received a response to the audit request, and he indicated to her that he could not locate his documents and wanted to know what to do about an extension. Ms. Smith explained that he would need to send in a written request for the 180-day extension and explain why. About a month later, the board office called respondent again. Respondent did not answer. On June 1st, we called respondent again. Respondent both stated that he would have a letter to the board office in the next 2 days. No letter was received, so we opened a complaint against the respondent on June 3rd. On June 10th, respondent sent us a letter indicating that he did not receive the first letter that was dated October 27th. He still states that he could not locate his continuing education documents and requested the 180-day extension. June 16th, we sent him a letter notifying him that a complaint had been opened and to respond within 14 days. July 6th, he emailed Mr. Cothran stating that he did respond to Ms. Smith's letter and has elected to go inactive. A few days later, this was referred to legal counsel, and July 14th, we received his affidavit for establishing inactive status. So it's a little convoluted, but this has been going on since October, and I wasn't sure how the board wished to proceed.
Elderly, are we allowed to suspend his license based on? I just think that but this is before he became inactive. It's kind of like now you caught him red-handed. He said, "Well, I'm just gonna go the easy way out." We're basically teaching him to have a way out too easy. I'm just asking a question.
Guidelines. Is it in here?
Yes, Mr. Chairman, my question is, can we, before he gets into inactive, why should we let him have an easy way out if he's been playing the game for that long? That's my question.
My immediate response, without looking at the guidelines we have, is the board can suspend anyone for a violation of their rules.
Yes, sir, Mr. Balzer.
Just a question. Do we know if this licensee was
is active in the jurisdiction he resides in? Yes.
Do we know his status with that jurisdiction?
I believe it's active. I'm not positive.
Question.
Yes, sir.
if we suspend his license, then it'll automatically be reported to his board, right?
That's how it works.
Yeah, it's reported on the National Disciplinary Database for that profession. So it would be reported to other
Well,
states.
they'd find out about it, wouldn't they?
And I believe also on the suspension, he has to apply to us to have it reinstated.
Or suspension?
No.
Usually it's for a specific period, although
Okay.
in some cases there is an
Sometimes we do indefinite suspensions if they need to meet certain requirements, but it's generally just for a time period.
Make a motion that we suspend his license indefinitely.
Second?
Second.
Take the
Is
laws
that
and
the
rules
same
of
as
things.
revocation indefinitely? Will there be any
it would need to be
contingencies to
suspension
that?
until he meets a requirement
And-
of some sort, right?
Suspension until he meets the continuing education or revocation, or, I guess I need a little more guidance than indefinite suspension.
Mr. Chairman, I think that we have done in the past, that when we suspend somebody, and then we make them, for a period of time, then after that, we make them reapply. It means they start all over the process all over again. That done before, we've done it before, so. Indefinite might be a little bit tough on him, but he's willing to make a condition. I guess the nature of my question earlier was that if everybody says, I'm get caught handed, okay, in that case, it's kind of like when the police stop you for a ticket, I'm sorry, I'll not speed again if you just let me go. No, they're not going to be that easy on you. I think that when I get his attention a little bit.
Al?
Is it possible for inactive status dated at an earlier date different than the actual receipt by the office? In other words, what his inactive status effective date was what? The date? In July, and
When it was notarized.
did he request? Okay, but and it may not be allowed. But is it in his case? Did he ask for it to be retroactive at all? Okay.
Francis explained to him when he inquired about it that you can go inactive as of the date you go inactive. It doesn't forgive
Okay.
whatever you
Thank
did or didn't do for that period beforehand.
Thank you.
Okay, we've got a motion and a second on the floor, but we've also, an indefinite suspension does not necessarily, we have to put a condition on that, or,
I'm just not sure how to proceed with an indefinite suspension. I feel like there needs to either be revocation or suspension for a time period or until he meets the continuing education or something. 'Cause if you just
Chairman,
suspend indefinitely, you can't suspend indefinitely. There has to be some point of end date.
Mr. Chairman, I will amend my motion to suspend his license until he meets all the requirements by the state of Tennessee, including taking and passing law and rules exam, and he's subject to a fine as well.
second is okay with that amendment? Who was my second?
Yes.
Okay.
We'd need a
I'm okay.
number amount on the fine.
We
Get that in the
We have
motion?
in our rules that it's,
Which one?
depending on if we consider it to be mitigating factors, normal, or aggravating factors, which I see it to be an aggravating factor in this case. Now,
What page are you on?
page 9, on the misconduct, pink pages. It's the very top line item. Failure to maintain continuing education records for 4 years and to furnish such records to the board for audit within 30 days of the board's request. And Francis requested it 3 times? Okay. Well, to me, that's $3,000, but.
Are we just having discussion now, or
Yes,
are we
we're
gonna,
still-
we're not
We've got
gonna
a
amend the
and a
motion?
second. No, we've got a
Okay,
motion and a
okay.
second. We're still talking about
Okay.
the dollar amount. We may still have to amend the motion, but that's okay. We may still have to amend the motion. We'll see. Yes, ma'am.
This is perplexing me a little bit because of the inactive status. Now, in response to this, could he just pull his license and not pay the fine? I mean, what could his response be to this?
Any Registrant can voluntarily surrender their license.
So if he did that, then what we are doing would not affect.
Well, the fine would still be in place. We'd have to go to a formal hearing for it to be finalized, and then that would just be a judgment against him. And, I mean, that goes to collections, and I'm not terribly familiar with what happens to it once it goes to collections. But that is what would happen. It wouldn't, until it's finalized from an order, it doesn't really exist, but once that exists, it will stay with him.
I guess my perplexity is that you've got somebody that's inactive. What does suspending their license do? And so I'm trying to connect those dots.
It informs his home board that he has
Thank you, Rick.
received
So
illegal.
that's the point, is to
Right,
inform the home
to
board.
let them know, and then they might take action against him. I don't know.
Action against him. I mean, he isn't active right now. He could always become active again if he wishes to. He'd have to go through those steps to become active again.
Al?
Just to build on this discussion, remind us.
It means that they have stated that they are not practicing in this jurisdiction, and they will not practice in this jurisdiction as long as they're inactive. And I believe some of the requirements are a little less, such as continuing education, because they aren't practicing.
So to reinstate their license.
Right, they would have to submit their continuing education hours prior to reactivating. Right, the only thing they're exempt from is the continuing education and the professional privilege tax, of course. They pay the same registration fee.
But to go from inactive back to active.
Right. Yeah, just the 2 years prior to their request, they have to have the hours. Right.
If they wish to be licensed again, they would have to completely reapply, and the board would consider it as a new application, but there would also be this history on their record of being disciplined and revoked.
Where are you, and then Ricky next?
My concern is that this went on for a year, and we do have documentation, or we have the postal record that the letter was delivered, and that's contrary to what I think he makes one statement that he never got that first letter. So I think the guy's just, he got caught with his britches down, and now, and he's, as somebody said, trying to take the easy way out.
We sent him 2 letters in 2014, one in October, one in December. The first communication we can prove he did receive was the email in January, because he responded to it. So we sent him 2 other letters. We can't prove he got those first 2. He may have, he may not have. But he's definitely known about this since January.
I'm looking at the chart that Susan talked about, and I agree with what she was looking at, and there are another couple that I guess could be in the category, and I agree that it seems like it would be in the aggravating factors column, because the evidence is he wasn't truthful about it with the board. I don't see that that's something that gets a suspension or a revocation. It's not listed in the column out there, and maybe my question is, if he's fined, would that accomplish the same thing that Rick is talking about in terms of suspension? Would the other boards his other board be notified that he was fined by our board?
Would be notified. Just the way we do it, we do the consent with a letter of warning for anything that's less than a suspension or revocation. I'm not sure how his home state does it, but they will be notified.
I might suggest that following more closely to the table just leads to kind of consistent punishment, and maybe suspension it would be kind of a little bit out of bounds with the table, and that maybe a fine would accomplish the same thing as far as letting his home state know.
I withdraw my motion.
Yes.
We have no motion on the table. We have no second.
I'll give you a motion.
Well,
I want to make a motion that we impose the civil penalties as stated in our misconduct format. I see at least 2 rules that have been violated. Can you come up with a third? Okay. All right. The first being the one I've already stated. The second being failing to respond to the board's request of investigations within 30 days. And that is also a $1,000 penalty. So I would recommend that we impose a $2,000 penalty for failure to respond to the board and failure to maintain his continuing education credits as required by our statutes. So.
Second. I have a motion, I have a second. Any more discussion?
Does that mean that we assume that we're gonna keep his license inactive? I thought he's fine.
His license is inactive until he elects to become active,
Right.
or if the board had decided to take any action against it.
So whatever we do, this fine will still be, his license is separate issue, right? His license will continue to remain inactive.
His license is currently inactive, yes.
And we're opposing the fine based on the violation he violated now. Okay, thank you.
Discussion?
I wanted to add, it had been mentioned in the discussion about the laws and rules exam. Is that something the board wishes to include?
Yes, please amend my motion to include passing the laws and laws and rules, excuse me.
Second is okay with that? Frank, Jerry, I'm sorry. Frank
And
beside me.
John, this goes back, the action we take then is reported to his home state, good, yeah. And then they pursue that and take whatever action under their rules, yeah.
Al?
Just a question, a clarification. Does inactive status still?
All right, I think we've talked it around the table. We've got a motion, we've got a second. All those in favor say aye.
Aye.
And there better not be anybody opposed. Right. Ellery, is that the last one?
That concludes my legal report.
Fantastic.
The next thing on the agenda is the informal conference, and Mr. Holsart is still here, so whenever you're ready.
Oh, you guys are finished?
We're ready for you.
From our perspective, I don't know that we've had many full board informal conferences. Are there any rules or protocol, thank you, Hal, that we need to, most of our informals are done with 1 or 2 board members in consultation with the respondent. Didn't know if there were any special rules that we need to adhere to.
The first informal conference I've ever done. I am not aware of any special rules. I was just going to introduce it, explain the basis of the complaint, and then open it up to y'all.
I don't know if I'm sure most of you remember this, but Wilson sent some information to all of us about these formal hearings, how they're conducted, and
That's for tomorrow.
yeah,
The formal one is tomorrow.
yeah, I know, but I mean,
Yes.
he sent this information out
Yes.
previously.
Mhm.
So you're going to hand that out, that information?
Yeah, Mark Green, who is our chief counsel, over the litigating attorneys. He will be down here at 3 o'clock, or we can call him earlier if we're ready for him to discuss the formal hearing tomorrow.
Okay.
Does that answer your question?
Yeah, just asking the question.
Yes. Okay, John's gonna hand out, I believe those are copies of the plans, I think? Yeah. Okay. So this is an informal conference to discuss the complaint that was before us from my last legal report discussing it. I'm gonna give a brief overview of the issues, and then I'll open it up to the board or Mr. Holsart to begin the conference. This is informal. No disciplinary action will be taken. This is just for the parties to better understand the situation and for the board to give advice. In this case, the complaint alleges that the respondent, a registered engineer, committed misconduct by stamping phases of a project for which he was not qualified to seal by education and/or experience. And that was allegation of the complaint. Upon further review, these plans, we've discovered that these plans were only proposed plans submitted for preliminary review, and final plans were submitted later with substantive revisions. In review, 2 board members expressed concern that the plans should have been stamped preliminary, not for construction. And from my understanding of the case file, these plans were submitted to us by a codes officer who had concerns with them, and upon review they were actually preliminary and not fully submitted, but they were stamped. So the board believed they were final, and that, I believe, caused most of the confusion, and so that is why we're here today. Let's give you a few minutes to review.
Mr. Chairman, on the agenda, it talked about this one legal case report that has been ongoing on page 105. Are we jumping the gun?
It was the wrong page number.
We're actually on informal conference after, the 105 is in another place.
We can address that with the action items, I think.
That's my informal opinion. This is the informal conference. Okay, so I'll give the board members some time to review. And I know Mr. Holsart's here, so if you want to come to the
Before you come to the podium, sir, let me ask another question of our legal. Normally when we have an again, I'm going to probably beat this one more than I should, but normally when we have an informal conference, it's to determine if there's any wrongdoing that has taken place. Have we already decided there was or was not?
My understanding from the last board meeting when we discussed this case is that there was a stamped plan submitted to a code officer. They were not supposed to be final, but they appeared to be final. We thought they were final. Our communication with the codes officer, we thought they were all final. So that is the issue. The plans were stamped. They had some serious problems with them, which is why we opened the complaint. And then at the last meeting, we discussed that they were actually not final. They were submitted for preliminary review, but they were stamped and sealed as they were final, as if they were final.
I got all the facts, but here's the question then.
Yes.
So if we have this informal conference, we determine that there is some wrongdoing or not, whatever we determine, normally then it's up to this board to vote on that, correct? And we've normally maintained anonymity of who the case was against, except for the board members that have reviewed that, and they recuse themselves from voting or present the facts. So then how's this board, if we have to adjudicate this, going to then maintain that anonymity, or does that not matter?
My understanding of this conference is that that wouldn't be an issue because it was just to discuss this, because there's a policy that these plans need to be stamped preliminary, but since it's not a rule, we can't enforce it through disciplinary action.
So we're not voting on, there is no possibility then that we're voting or will be asked to vote on the correctness or incorrectness of this case.
I don't quite understand your question.
Well, so my question is, if we get in here and during this discussion and we find out that there is something wrong, then we can't vote on it because we know who the parties are. We know, whereas when we have an informal, all that is on the other side of the curtain with us. And that's what has allowed us to maintain some, what's the word?
If I could, just to give a little historical perspective. I'm sorry, did I jump ahead?
No,
jump
you
ahead of
didn't.
you? I'm
But, I mean,
sorry.
again, if the person there is a friend of mine, then how can I maintain my unbiasedness? Yes,
Yeah,
whatever
informals
crap that
before
is.
the full board used to be a common practice. I mean,
Okay.
we did them on a regular basis, but only in cases where the reviewing board member was convinced that there were no serious violations that would result in formal disciplinary action. Typically, they would result in informal action like a letter of caution, letter of instruction, something of that nature. So we would only schedule those before the full board when the board was convinced that it would not result in formal action. But obviously, as you're aware, in recent years, we've generally discontinued that practice, and typically informals are only held with one board member as part of an investigation process, essentially, prior to presenting it to the board. But in this case, it's already been presented to the board, I think, twice. And on the first occasion, it was authorized for formal action. It was in litigation. The litigating attorney sent it back after reviewing the case because she felt that the rules.
Yeah, she obtained additional information, the final version of the plans, which, from my understanding, are substantially different, and that based on her review and the new information that it was indeed preliminary and not final, which we could not tell when we first reviewed these plans. We did not know that.
Yeah, so it was reviewed again, and then my remembrance is that it was specifically stated that it would be an informal before the full board at the June meeting.
That's how I understood, just to discuss this preliminary stamped versus issue.
But this is a rare occasion, though, that we would do it before the full board. Yeah.
Let's go ahead and move forward, sir. I'm sorry. I just wanted to make sure that we were not poisoning the well if we potentially had some issue that came before us that would keep us from treating you fairly since we had been there, so.
Okay, my name's Bruce Halsart, and I'm the engineer that y'all are looking at all these drawings about. I'm standing up here in red as a big target, so I don't know what, I guess all I can do is first answer your questions. I have no idea what they are, but I'll give it my best shot, and then after that, maybe we can talk about other things. I don't know. So if you got any questions about this, I could probably explain to you how this all came about. Maybe that would help. Okay.
Yeah, please. Yes,
Okay.
good job, Alex.
Okay, back in a long time ago, a couple of years ago, I guess, had a contractor talk to me about doing some plans for a poor, struggling little black church that didn't have any money. And I said, yeah, okay, we can do that. So I met with the contractor, met with the preacher. We came up with a fee of $6,000 to do his little plans. And we started drawing his plans up. And I guess as an aside, I can tell you I've got experience, but we'll go into that later. I drew up some drawings, gave them to the contractor because he was on me. Oh, I got to do this. Oh, I got to do this. So he just beat me up really badly to get him some drawings, so he could make a preliminary estimate on the cost of this church. So he had a set of drawings, and they were sealed. I had my seals right up here on the top because as a self-taught AutoCAD person who just only this year came into AutoCAD 2015, I just moved over the whole base sheet, so I got a 24 by 36 drawing. It's got a seal and a signature on it, and then you change the date, you change the title, you put your building on it and all that. So yeah, it was there. It was stamped, okay? It wasn't marked preliminary but I've got a preliminary stamp that I hadn't used in 20 years. Anyway, I gave this guy a set of drawings, and he says, hey, I'm downtown in Clarksville. How about if I go by and see old David Roan and let him give you an informal review on these drawings and see what you got, see what you need to fix. And I went, hey, that's a great idea, because for all the churches that I have done, this was the first one in Tennessee. So I thought, hey, what a great idea. This guy's gonna look at it, tell me what all I gotta fix, and I'll go from there. So the contractor gave a set of drawings to David Roan. David Roan looked at them, and I got back, I guess what you have there, I don't know, with a lot of explanation about what needed to be done. So I went down to see him, and I said, we need to, explain this. And he says, I don't have to explain this to you. And I went, okay, we can talk about something like that later. I've had other people explain them to me, and I've gotten 5-page correction letters before, too. So next thing I knew, this went to the board, and nothing happened. Then I talked to one of the lawyer guys, and I talked to two of them. I talked to the first one, and the first one referred me to the second one. The second one said, well, what do you want me to do with this thing? And I said, make it go away, because this is the a case of no good deed shall be unpunished, go unpunished. And I hadn't heard anything else until a couple of weeks ago. I got a phone call that, oh, you've got to come down to this meeting. So I thought it had truly gone away, and I guess it hadn't, and here I am. So you've got pre-preliminary drawings there. I've got the finished product here. I tell you, if you guys want to find me, it's just double jeopardy, because I already paid an architect to take care of that. Here's the drawings right here. And if you want to look at a picture, I can show you a picture of the church. The church is up and running, and they're expanding the parking lot and loving their new building. And an architect did all the other stuff. He looked at my drawing and said, we can fix this. So we went through and redid the drawings. And then as changes came along, he did it all. But anyway, I got an architect's stamp on the drawings. He's got my check. And that's where we are on that part of it. Now, if you need to know about experience, or I can wait, I can wait on
Stop
that.
right there, because I think we need to, Al?
Well, one question. So the set of plans that we have.
Got two sets. We got two sets.
The set's still by the architect.
This is the first.
Mm-hmm.
So my question for you is, were you aware, or what?
Like I told you, when I first set up my drawing, I dragged over 24 by 36, and it had my seal and my signature on there, and all I did was change the date, change the title, change whatever, and then just start going from there. So it was on there, yeah. With my signature, with my seal, I did that, yes. At that point, there was not going to be any use, because I did not formally submit. This was an informal information gathering thing, just like this is an informal hearing. David Roan was going to look at him and say, well, you need to do this, and you need to do that, and you need to do this. And that's what I was looking forward to. I sure wasn't looking forward to coming down here, not for. Well, had it been a formal submission, yeah, but it really wasn't to Mr. Roan. Okay, it was on the drawing, mea culpa, I put it on there.
What does the seal mean to you, though? The use of your seal, what does that indicate? Document with your seal on it, what does that mean to you?
I guess you're gonna tell that, yeah, it's been designed in accordance with reasonable care and everything, but like I said, these were just preliminary, and we're subject to change. I guess he wouldn't, except for based on the nature of the whole. Bruce Saunders going down and seeing David Roan and saying, hey, Dave, look these things over, let me know what this guy needs to do. it was informal like that. I sure didn't fill out an application form and say, I'm submitting these drawings to be for approval for, what in the world, City of David Christian Center.
And you had indicated you wouldn't mind sharing your expertise or your area of practice, but can you start back? What was your formal education? What discipline of engineering were you degreed in?
I was educated at West Point, graduated from there in '75. Received a Master of Science in Engineering Management from University of Missouri at Rolla in 1981. I went over to Saudi Arabia from '82 to '85 and worked 3 years over there on the Ministry of Defense and Aviation headquarters project with the Saudi Arabia Pentagon for all intents. As project manager over there. Came back to the States, got out of active duty, went into the reserves, and I've worked with a series of architects since 1986.
Okay. And so your degree, understand what your degree is. When you sat for the PE exam, which discipline?
Oh, okay. While I was over at Saudi Arabia, I finally got 4 years worth of experience, okay? And under the auspices of the state of Minnesota, they sponsored a bunch of us, 30 or 40 or something like that of us over in Saudi Arabia to sit for the PE exam. So I took it while I was over there.
Civil engineering then? Do you recall, or was it general engineering?
It was engineering.
Okay.
And so we did a little, whatever, I guess if I had to have a degree, area of expertise, it would have in fact been civil structural.
Subsequent, okay, so structural was your primary focus of area of
Civil
focus?
mostly because I've done mostly civil engineering.
Okay.
But I have, in fact, I've done other also.
And then the other sheets that are included in both sets of documents, the electrical, plumbing, and mechanical, what was your experience as it related to your expertise in those areas?
I have since 1975. My father was an electrical engineer, so I used to do his drafting for him. And after that, when I would pick up a project, I would have, call him up. Dad had helped me with that. And then with the mechanical and plumbing, I learned that on the job.
Thank you.
Jerry, your next, please. No,
Harold, thanks for leading into the question. Is that Mr. Houston? I got a question. I'm an electrical engineer by trade.
Okay.
You said that you know how to do electrical engineering because over the years that you have done electrical work?
Yes, sir.
By experience?
Yes, sir.
Correct, okay. So let me ask you a question. If you come to the power company, and in your E1 drawing, you will call for a transformer, do you know how to size the transformer?
Yeah.
And you kind of walk me through
Yeah,
your thought process, how you size the transformer.
Calculate the load that you're going to have for your building. Take that into KVA, and it should be there on the drawing anyway. So you figure out what KVA that you're going to have for a demand, and that can only be like 80% of your transformer. So you try to size your transformer for that. Now, I don't know what they've got out in Montgomery County, but that's usually the way that we would do that. We'd figure out our load and then let that be 80% of, like your incoming service. And necessary if we needed a new transformer.
Very good. How did the 80% come about?
If you do all your basic calculations for demand for your receptacles and such, and you just put it all together, your incoming service has to be greater than your demand. Your demand can't be more than 80% of your incoming service. So.
Okay, with that say, at what point in time do you go back to the code book to give you some guidance as to what you're talking about is a diversity factor? How do you derive?
Oh, yeah. Okay. Diversity factor comes into that.
Which section of the code do you look for it?
Say again?
Which section of the National Electric Code do you look for the diversity?
I'd have to go back home and get my code book and look.
Okay. So 80% is not is more a rule of thumb as opposed to the code, right? Is that correct?
I'm sorry.
What I'm saying, 80% is a rule of thumb.
Yeah,
It's
rule
not,
of thumb.
It's
yes.
not a scientific
Okay, yeah.
calculation.
Yeah, because you got the diversity in there too. Yes, some things might
Okay.
not be used as much as others. That's correct.
Assuming that you use a 50 kVA transformer, 50 kVA transformer, would you be able to determine the available short circuit current at the service entrance?
I'd be able to what?
Would you be able to determine or calculate the available short circuit current of the fault current for protection?
I could do that.
You do that? Can you kind of tell me how you do it?
Oh, God, not without going back and getting my code books, I couldn't, yeah.
Okay, thank you, Mr. Chairman.
You know,
Thank
it's
you.
not like I do this every day, but,
Thank
so
you.
my code books are my constant companion.
Thank you, sir.
Questions, Ricky?
I want to make sure that I understand, is the degree you got, the engineering degree you got, what discipline was it? Is it a civil engineering degree?
I got an engineering degree.
Okay. Okay, so,
I have a BS in engineering.
okay. Okay, and looking at the mechanical drawing at the HVAC system, what type of heating and cooling load calculations, what method do you use to size the equipment and the airflow?
I just go into my ASHRAE book and look at that and figure out the volume of the place and how much we need to change the temperature to make it work,
Okay.
to heat it or to cool it.
Okay, and as far as how you came up with your airflow quantities for each space, what?
That
Can
came
you
out
tell-
of the code books for assembly areas and restrooms and things like that.
About the heating and cooling supply? How'd you come up with heating and cooling supply amounts to each
They're
space?
based on the volume of the rooms and what they needed, the temperatures that they needed to be at.
Can you tell me the basic equation that you use to figure airflow?
Not right off.
Okay, thank you.
Just, and I know Mr. Humphrey, who is, I guess, the architect of record on the final set of drawings. I guess my question to you, Mr. Holsart, I'm assuming you're a client of Mr. Humphrey, is that correct? Okay. Was he aware of your sealing the documentation?
Oh, I have known Jim, and Jim works with Tom Anderson up in Mount Juliet, and I've known Jim Humphrey for years, and I called him and I gave him a set of the drawings. So yeah, I'm sure he was aware of it just by virtue of seeing my signature and seal on the drawings. He also knew the same thing I did. It was a preliminary submission, informal as it could be.
I may be missing it in the quote-unquote preliminary set, but were the architectural drawings also in that package? I see A2 dated February of 13
Okay.
and A3 with your seal on it.
Okay.
And those are elevations, and then if I look at the subsequent drawings, May of 13, as I'm seeing, those were sealed by Mr. Humphrey.
Not May of 13, unless he didn't change the date. Maybe they were. I don't know. You've got I'm unarmed up here. You know, like I say, I'm just a big
I
target.
understand. Well,
So I
and
don't know what you
I'm
got in
glad
your
to.
hand.
Do we have a set for him to have access to, John? You don't have this packet that
I
we're?
didn't bring it with me, no, sir.
Yeah, maybe we can avail him.
Give him a.
I'm curious, and I can't do on the spot comparisons, but I'm assuming that some of the architectural drawings from the February timeframe were subsequently stamped by Mr. Humphrey. And my architect friends, could you advise that would that be a correct interpretation of the package or not? Looks like Mr. Humphrey started over. Okay. Well, I just found it curious that you would have stamped architectural drawings as well, but do you have, if you look at let's see, where are they? Let's see, let me make sure. There's a drawing labeled A1,
Okay, yeah,
and then there's A2.
yes, sir.
Are you, and then there's A3, and A4, A5, A6 with the standard details and language. Are
Alright.
you also of the opinion that you are qualified to prepare architectural drawings?
That's why we're here, isn't it? Because
So you're saying you are?
I would believe so, yes.
Okay. I appreciate that.
Like I say, this is my first rodeo.
Understood.
All right.
Anything else from the board?
Chairman,
Yes, sir.
to go back to Hal's question and comment, there are 6 architectural sheets in the first submittal package, and the architect who started over has 10 sheets in his package. So the degree of understanding is much higher from the architect than the engineer in putting together architectural sheets.
Mr. Huston, I got a question back to the electrical drawing. We talk about the,
Okay.
can you go back to the second set? You have the E1.
Uh-huh.
There's on your electrical notes, there are some note number 3, you say contractor to verify fault current at power company transformer prior to ordering or
Yeah.
disconnect switches.
Okay.
Are you leaving it up to the contractor to decide what switches you're buying, or you have to tell them what to buy? Can you tell me what size switches you're buying? Note number 3, so you
I
just.
see the note, yes, sir. I'd have to go back and get my NEC to tell you how to figure that out, the size of your switch.
Well, if you look at E1
Yeah.
on the panel schedule,
Yep, the panel schedule, okay.
what is a fine print right there? Minimum breaker AC, what, to be what, 10,000 amp symmetrical?
Sorry, let me get back to that.
Go back to
E1.
that. E1, yeah. On the panel schedule, the final drawing set. See the 10,000 amps right there?
I see the what, sir? I'm sorry.
The 10,000 amp, you look at the panel schedule towards the end, the last line in a rectangular box.
The last line, what, connected load?
No, the last line in the box, it says note minimum breaker AC to be 10,000 amps symmetrical.
Must be missing that somewhere.
Very, very bottom, yeah. On E1.
Oh, didn't look far enough down, okay. That doesn't sound
So
right.
when you say that you're gonna have to look up the code book,
Yeah, no, that just, okay.
I mean, the answer is in front of you right there, right?
Say again?
The answer is in front of you. If I'm
Yeah.
a contractor, I would buy a minimum of 10,000 symmetrical
Good
amp.
luck, yeah.
So you don't
think
need to
that's a
do the code
misnomer.
book. So somebody needs to know. As a designer, in my
Yeah.
mind, when I ask you those basic questions, you got to be able to say, well, based on the note here, if I were to size my breaker, minimum, I had to be able to interrupt 10,000 amps. That's what the answer I'm looking for. I'm not looking for an answer to look at the code book.
Okay,
The code book is not going to help you at all.
okay,
Thank you, sir.
thank you.
Any questions?
I guess I have one. What were your thoughts when you, in your original set of plans that got submitted, where you obviously had A sheets, do you just put your seal on every sheet you set up, whether it's architectural or whatever? Or do you think should be able to seal these architectural sheets?
I guess in retrospect, I shouldn't have put a seal on them at all there for a preliminary submission, but like I say, it was,
Well, let's say, for an example, that you submitted it and they reviewed it and said it was all right. Would this have gone through?
okay, so if he had submitted it and it
Isn't
had
that
been
a
approved.
dangerous thing to do?
I'm sorry?
I said,
Yeah,
you submitted a set of plans with your seal on it.
I didn't submit them,
You put your seal on these plans.
okay?
And so when you do that, anybody that looks at it has the right to assume that those are finished drawings.
Because they weren't stamped preliminary, okay.
Yes. And you sealed, the ones I'm looking at, architectural sheets. Why did you do that?
Why did I do that? Rick? That's what, I told the contractor, we were just gonna do these sheets for a little small church, and that was it. At the time, I don't think either one of us believed it was gonna be a very complicated job.
But you said that you were aware that the contractor took it to the
Well, he asked
planning
me, he said he
department
was
to
going
review.
down there, and I went, yeah, that's fine, but it was like I say, it was for an informal, this was the first church that I had done in the state of Tennessee. And it's the first thing I had ever submitted to Montgomery County.
In the first place, it's not the planned review of a code department to do your code review for you.
That's true. I've heard that before too. Anyway, I figured he would look them over and he'd say, you need to work on whatever, and I would end up with a correction letter and respond accordingly.
Did he tell you?
And then I was looking for that from him, for this informal review from him, and then go back and fix it all and make it all look like he wanted it to look, and then do the formal submission.
Apparently, he didn't think so.
I guess not. Don't ask me why. It was supposed to be just a,
I think probably it was because the contractor brought it to him hoping he'd get a permit.
no, heavens no, that was never the intent of that set of drawings.
Well, before Mr. Thompson says something, I hope you understand that whatever your intent was, whatever the contractor's intent was, whatever that person walking down the sidewalk's intent was, has no bearing. Once you put your stamp and seal on that, you have made it, there's some intent to it. You have made it to where it possibly could get built in whatever fashion you put your stamp and seal on it. Doesn't matter. I could put my stamp and seal on this document right here and hand it over to somebody, and it becomes gospel, and somebody can take that and try to do something with it. Because your stamp and seal means something more than just, oh heck, I put it on a AutoCAD drawing to be left over. There's so many instances in our profession where people have stamped and sealed something and thought, it's just casual, whatever. But it's your stamp and seal. And that means something. That means something to the contractor, the building officials, and the inspectors. And this church could have possibly got built in this condition. And we could have people possibly at risk in the state of Tennessee because it got built in that condition. So I'll go ahead, Mr. Thompson.
Just another code question, and I know why these get submitted, because it's assembly occupancy, and the state requires that we issue drawings on assembly occupancy. How did you determine, or did you determine the need or the lack of the need of sprinkler system in this assembly?
Based on the code book for A2 or A3 assembly. If you were under a certain number, under 200 people and under 2,000 square feet or whatever, you wouldn't need to sprinkle it, and that seems to be the driving force behind all these little tiny churches is we just can't afford to sprinkle them, so that we need to make it small enough so that we won't have to.
Okay, you've answered my question.
Just a question, Mr. Holzer. What other states are you licensed in?
Minnesota, Ohio, West Virginia, Kentucky, Tennessee, Missouri, Georgia, and Oregon. I did one project in Oregon, and that was 20 years ago. Well, no, it was strictly an engineering job in Oregon. I've done, let's see, Ohio. I've done several architectural things in Ohio, and some of them were a lot bigger than this one here too. I've worked with the state for experience. I've worked with the state architect person. I've worked with the state plan review architect peoples.
So in Ohio particularly, you have worked on projects where you have sealed architectural drawings? Yes, I have. Okay. And that, because you had mentioned earlier that this was the first project you had done.
This was the first one in the state of Tennessee, yes, sir.
Right, okay. And I wanted to qualify that I interpreted that you were implying that you'd had similar experiences maybe in other
Yes, sir, I have.
jurisdictions. Okay.
I've done, and somebody was asking about one of them being sprinkled. I did a 12,000 square foot church there, and told this guy he's gonna have to sprinkle it. And in the city of Columbus, they want you to pay for all the water you're ever going to use up front, and it was going to cost him $40,000, and he wasn't excited about that. And I kept telling him he needed to do it, and finally the inspectors came in and shut him down and made him spend the $40,000 to sprinkle the building, because it exceeded the code requirements of space and occupancy.
And as far as you know, those projects in the other jurisdictions were constructed and are now occupied?
Well, they're up and running. Everybody's washing them there twice a week. Yes, sir.
Okay, thank you.
Rick?
Oh, I'm sorry. I left it up by mistake, sorry.
Is it appropriate for me to ask if he has been disciplined in other jurisdictions?
Issue today, no.
Other questions?
I'll make one comment. I think it's interesting that the original set of drawings showed the actual building area to be 3,200 square feet. And the architect's design, James Humphrey's design, says it's actually 6,336 square feet.
Okay.
Showing a smaller number allows you to do things that the larger number won't.
Sprinkle it.
So you're telling me that you put that number on there so that you didn't have to sprinkle it?
Oh no, I took it based on the square footage that we had from the first
Are
design.
the two designs, the size is different?
Say again? They are. What did Jim? Jim's got 6,000 square feet, and I've got more than that, I believe, Donna. I've got, oh, wait a minute. Total gross area, 3,200. Hang on a second. Okay.
Looks about the same, but somebody's off by a factor of 2.
Yeah,
Must have been
I
the
think
scale
you're
on those
right.
AutoCAD drawings, but never sure, are you? All right, any questions, Ricky?
One more. Was there a specifications book that went along with these plans, the
sir.
finished plans?
No.
Okay.
As a matter of process, Ellery, what is next? And perhaps the chair will allow the respondent to make any final statements, but then past that, what is the protocol or the process?
My understanding of informal conferences is after it's been concluded, the board would, since we'd already decided prior to this that there would be no disciplinary action, the board would issue a letter of caution or concern about this issue.
Final comments? Oh, Philip, I'm sorry.
Mr. Hudson, the reason why I will speak for myself as an electrical engineer.
Yes, sir.
I ask you those questions, so I want to, at the end of the day, when I'm worshiping God in that church, I don't want the place to burn down.
Well, I understand.
And that's why I was asking you those questions. I was leading you into all this.
Yeah.
I'm not questioning whether you had the ability to do it. But if you, anytime when you put the stamp on that E1 drawing, it gets my attention.
Okay.
Because I work for the power company. And if you size anything incorrect, as a matter of fact, I can push a little bit longer. How far is the transformer away from the building? And do you need to know how to size the cable for voltage drop?
Yeah.
I can go on, but I think at the end of the day, I'm trying to establish an understanding. I have no question about your experience, but I just want to make sure you make me comfortable that when you put your stamp on it, you're good to go. Thank you, Mr. Chair. Thank you for answering those questions.
Okay.
Okay, final comments, statements?
Like I said, no good deed shall go unpunished, and I guess that's why I'm here. Like I say, I've designed several churches in the state of Ohio that were substantially larger than this one here with no deleterious side effects. I've worked with, I've got about a dozen architects' names here that I've worked with since 1986. And like I say, I've worked with, and I've learned a few lessons the hard way too. And this is why I had no problem with sending this thing off to David Roan. Everybody's got their certain, you've got a hot button, and I'm sure you do too. So I figured I'd find out what his were, and then we would go from there so that I didn't get dragged through a knothole on, well, I want to see such and such, and that's what I really look for. In fact, when I was working with the state of Ohio, I was talking with the plans review guys down there, and they were kind enough to give me a 2-sheet handout and said, here's the things we look for when we go review plans. So if you've got all this stuff on your plans, that's fine. I went to this Washington County in Ohio where there was an architect that was the plans reviewer. And we had several discussions, and it was only a 2-hour drive each way to get down there to meet with him about some stuff. So learned some lessons like that. And like I say, it was supposed to be an informal thing that's been blown so far out of proportion about this. I mea culpa about putting my seal on it, but I sure didn't mean it as a submission, much less a formal submission. And like I said, the contractor just beat me up. Oh, he signed this thing. I need your drawings Monday. I need them now. And he all but came to my house to pick up drawings. So, and I don't work well under pressure, as you can probably tell from standing up here answering your questions, Mr. Leon. Oops, excuse me. I had a picture of the church if you want to see it. I went by and took one on the way down here.
All right.
I could have one more thing. Like I say, I talked with Jim Humphrey, and he's done this, and yeah, I learned a lesson that from now on I'm not going to do any more architectural drawings. And if somebody needs something, I just refer them to him and not me. It's not worth the headache and heartache and all that, and Jim needs to make a buck too. And like I say, he already got it from me, so.
Couple comments and then we'll discuss. First of all, no good deed goes unpunished. Sir, this is not really an act of karma. This is more an act of not following the procedures that we have outlined in the state of Tennessee.
All right.
Karma's when you walk out and that limb falls on your head, but
Okay.
that's not what happened here. What happened is you didn't follow our rules. You stamped things that you shouldn't have. You made it out like this was a set, whether that was your intent or not. The interpretation was that it was to be used to go construct something, number one. Number two, we as an engineer, if we respond to what a contractor says every time and let that be our gatekeeper, we would not have anything in the state of Tennessee that would last very long. So,
I agree.
well, then you should put that into practice as well. The last thing is, as I go through this process and we go through these questions, it seems like everything you did may be technically correct, may actually have worked. I doubt it. But what we end up with is we end up having to protect the health, safety, and welfare of the citizens of the state of Tennessee. If this drawing that you put out first would have gotten on the street, and it very easily could have, very easily. Thank God the building official in Clarksville knew what he was doing, or it could have. That would be troublesome. I'll tell you a quick story, and not to bore everybody, but I'll tell you a quick story. I came from a manufacturing environment, and the statement you made earlier really concerns me, and here's why. We used to always, we had quality control people, right, into the line to see what you screwed up on.
Okay.
So what you did is you screwed up on something that was real obvious so that they didn't catch all the really nitpicky things that were really wrong with it. And when you tell me that you go to everybody and find out what their hot button items are and find out what the big things they look for, are you telling me that the rest of it doesn't matter?
No, I'm not telling you that at all.
Well, I mean, that's the insinuation that you made in your
apologize for
testimony,
that.
and that
No,
really
no.
irks me because
No.
at the end of the day, we as engineers are called on to design something that protects the health, safety, and welfare of the public, not just what gets us by, what gets us through code, what the hot button is. I'm concerned. We've already evidently made a determination that this is not a real big deal. But, I mean, this is the kind of thing, in my opinion, and I'm just one person, that really concerns me about our profession and concerns me about the cavalier attitude that we've taken towards how important our stamp and seal is. So, that being said, thank you very much for being here. You direct us on which direction we need to go because I'm confused.
What generally happens at the end of these informal conferences is that we would just issue an official letter from the board stating our concerns about this situation, and that would be the resolution at this point.
A question, Mr. Chairman and Ellery. Can we require the registrant at least to be familiar with our law and rules by taking and passing it as part of a letter, whatever letter we issue him? I think it's just good to reiterate that. Thank you.
Jerry.
Just for the record on this, I've got a concern, and where we've got an engineer who has who's a civil engineer doing architectural drawings, and that bugs the hell out of me. Engineers doing architectural work. There's no way on God's little green earth I would be doing engineering work and put my license on it. I'd get the appropriate professional to do the work. And this is a big concern. And I've got heartburn on this, and I know of several architects that have the same thing. And I think it's about time we start defining practice of architecture and engineering, so we don't see cases like this.
don't know whether this is appropriate time to say this, but if we ignore the preliminary set and look at the final set, the mechanical electrical drawings scream that it was done by somebody who doesn't know how to design these systems. And so I think there's a danger not only architecturally, but mechanically, electrically, and that mechanically including plumbing, HVAC and plumbing, and the electrical drawings don't make any sense, don't have any specifications, extremely incomplete. The answers tell me that the basic knowledge isn't there to do that. So I don't know how that fits into this situation.
Do we have other options besides issuing a letter?
Well, the issues that were before us at the meeting last time was the competency issue, which from the reviewers was fixed by the new drawing. So the competency legal argument is kind of abated by this new argument. And the next one, or by the new drawing. And then the other violation was the stamp issue, but it's just a policy and not a rule of ours that preliminary drawings be stamped preliminary. I think this is something that the board can all agree this needs to be a rule going forward. But since it is just a policy, we cannot discipline based on that.
Not suggesting that this is the direction to go, but if there is discovery through the course of investigating a complaint of other concerns, does the board have any authority to investigate the merits of those discoveries?
If they are completely separate issues, depending on what it is, then yes. But since the original issue was competency, I believe that that has already been covered.
Competency in which profession?
When we reviewed these new plans, we submitted them to two members of the board, both an architect and an engineer. And my understanding, and from the discussion last month, that the new plans abated the issues that were in the first drawing.
I don't see a whole lot of difference in the engineering drawings from either set. And what I'm hearing from my colleagues is they have some issues with these not being executed properly.
My
Am I
understanding.
Go ahead.
Oh, sorry. My understanding from the reviewers and that we discussed at the last meeting is that that had been taken care of, and that the issue of concern to discuss today was the preliminary stamp issue.
Can I speak, Robert? I think where we got a little bit off track and confused here was I went back and looked at the minutes. The minutes do say that Mr. Lim made a motion to at my suggestion, have an informal conference. These things would have been uncovered in that conference where the engineer and the architect reviewer and the registrant sat down and went through this. Then we would have had this information to deal with. It wasn't as obvious at that point. So things have gotten out of the barn, so to speak, now.
Else?
If we're done with this topic, can we take a recess?
Yeah, I was going to suggest that, but we do need to have a letter written. Is that correct?
Yes, that's correct.
Well, a letter of caution or letter? I guess letter of caution, isn't it?
Well, or Ellery, what is on the table?
The options for this case is really just the letter at this point. I mean, I can.
Letter of warning, letter of caution.
Yes, and the laws and rules exam.
Passing.
Is that your? Make a motion to accept the recommendation of legal counsel as it relates to this case.
Second.
All in favor? We've discussed it to death. All in favor?
Aye.
Opposed?
Aye.
Motion. All right, let's take a 5.5 minute break. And then we'll go to the director's report.
Numbers, talking about,
Pass rates.
yeah.
And,
Is everybody here? Phillips here. Steve, I saw on the phone. That's okay.
Hey, Rhonda. So anyone can go on the website and figure out how to do it, right? The instructions for applying for the.
All right, let's call us back to order. I'm gonna go ahead and take a quick liberty with the agenda. I believe we have Mark Greens here. And let's go ahead and move you up since we have fallen very much behind, and I apologize. My first time through on this, and I'm herding cats, so
Inexperienced
sometimes that
chairman.
inexperience and all that. If you don't mind, go through the review of formal hearing procedures with us, and then we'll let you get back to doing something semi-productive.
Well, Mr. Chairman, this is certainly productive. I'm happy to report, as you all well know, that there will be a formal hearing tomorrow. And I'm not going to talk about any of the matters related to that issue. That will be done before you tomorrow. I just wanted and Ellery and Tony Glandorf, who's also chief counsel with our department, who I asked to come down here. He actually, A&E is actually one of his areas of responsibility. I, for the past couple of years, have been the chief counsel for litigation, so I thought it would be good if I came down and discuss that, the process that you're going to go through tomorrow. It's been a long time, I know, since there's been a formal hearing in front of the A&E board, and so I don't know if any of you have ever participated as sitting on the board in an administrative hearing. One, two, couple. Okay, so it's much like a trial. It's much like you, as the board, kind of sitting as a jury, determining facts, determining whether or not the state has met its burden of proof for allegations, whether or not you basically will determine if there are several witnesses. You will determine whether or not you find whose witness is more credible than others. I know in this case there will be expert witnesses, so you will obviously get to hear the witnesses being questioned by both the state's attorney and the respondent. The respondent may be represented by counsel. I'm not 100% sure on that, or they may come in and represent themselves, which can oftentimes be somewhat difficult because you have a person who is not familiar with the procedures of law and the UAPA and the Administrative Procedures Act. That's what the UAPA is, and that's what this hearing will be guided under. There will be a judge who will sit with you. That judge will not make findings of fact, or that she will not rule on anything as far as what you will make decisions on, i.e. whether or not you believe an allegation has been proven or whether or not you believe somebody has committed an act. She will make determinations on law, procedure. she will make sure that that the department and, well, the parties are following the Uniform Administrative Procedures Act accordingly. She will advise you. She will give you guidance. You can ask her questions if you don't understand a procedure, or if you don't exactly aren't clear on a matter. You can ask the judge. She is there to guide the process, but you are here to make the determination as to the allegations that are made. There will be a court reporter who will be sitting on the end, probably one of the ends up here, who will take and make a record, make a transcript of the entire hearing. That's very important because sometimes it's not, doesn't happen often, but we do get appeals to Chancery Court from decisions that are made. And they take the transcript with all the record, and the Chancery Court will review that based on whatever the appeal is to make a determination. The state's attorney will get up, just like in a courtroom, and they will make an opening statement. They will tell you what this case is about. They will tell you what the allegations are and why the state believes that the allegations made in the notice of hearing and charges are and should be found as the proof is going to be presented. That is not evidence in and of itself. The opening statements are just kind of a roadmap of, this is the state's case, this is where we're going, and this is what we hope to prove. What's evidence is exactly what's introduced formally into the proceeding. After the state's attorney has gotten up and made an opening statement, the respondent or the respondent's attorney will get up and will make an opening statement. And they will say basically whatever, they will make the argument. They will do the same thing of giving you a guideline as to why the state's allegations are not provable or cannot be found by the board. And so that kind of sets the stage, and then we open proof. And the state will go first. We'll call witnesses. I'm not for sure how many witnesses are in this case, but the state's attorney will go through and they will start laying out the case. You will have a copy of the notice of hearing and charges. That will be handed out to you. So you'll see what the allegations are. And you will start to formulate whether, as you hear the evidence, as the case goes along, you will begin to formulate whether or not you believe by a preponderance of the evidence, that's the proof standard. It's not beyond a reasonable doubt. It's not clear and convincing. It's basically, is it more than 50% that the preponderance of the evidence shows that the state has proven the allegation in the complaint. And there will be, and I don't know how many, but there will be several allegations. Some you may find are proven, some you may find aren't, and that's perfectly fine and normal. Your job is to break it down per allegation and listen to the proof as it's presented. There will be exhibits that will be presented. The state's attorney has made copies for all the board members, for the judge, and for the court reporter to enter into the record. You will be able to you will be able to look at those exhibits. You'll be able to read them. You will have your copies up there for you to refer to. It depends on the judge, but, well, before I get there, after the state's attorneys are finished with a witness, then the respondent gets to question the state's witness, and they get to cross-examine the testimony that the state's witness has just given to you. This may go back and forth a couple times because after cross-examination, the judge may allow for redirect and recross. After recross, they usually cut it. They usually cut it off. But at that point, the judge, and I think Judge Mary Collier is assigned to this, and she allows questions to come from the board directly to the witnesses. So frequently, you may have questions of that witness, and if you do, you can ask the judge, may I ask the witness a few questions, and then you individually can ask questions of the witness. And you can do that for the fact witnesses, which are the people that aren't experts but have some knowledge. I don't know. I think basically these are going to be expert witnesses, and you certainly can do it of the expert witnesses. After all of the witnesses for the state have gone and the attorney or respondent has been allowed to ask questions on cross-examination, and you have asked questions of the witnesses, then the respondent will put their case on. They will, and again, it's very important to remember, just like in a criminal trial, it's the responsibility of the state to prove the allegations. It's not the responsibility of the respondent to prove they didn't do them. Their responsibility is to basically cast doubt or cast counter evidence that shows that the state can't prove their allegations. So when you're thinking about this, don't think, well, okay, now, Mr. Respondent, prove you're right. The idea is, did the state, can you offer any rebuttal evidence that the state is wrong? So the benefit goes to the respondent until you hit a preponderance of the evidence. So just kind of remember that, and not get hung up on, thinking that the respondent should come in and prove that he didn't commit whatever violations are alleged. This will go on after the state or after the respondent puts his witnesses on. He may have expert witnesses. He may, certainly the state will cross-examine his witnesses, be they fact or expert. And just like on the state's case, you will be able to ask questions as the judge permits. And when that's over, if there's no rebuttal by either party, then it'll move to closing arguments. And the state's attorney will get up, give their closing, basically saying, this is how I proved the case. And the respondent will get up and say, the state didn't prove their case and this is why. At that point, the attorneys and the parties sit down and it's turned over to you. The judge will turn it over to you for deliberations. The interesting thing about administrative law is, unlike in a criminal or civil setting, is a jury would retire for deliberations. But in administrative law, under the Uniform Administrative Procedures Act, under the Open Meetings Act, all of your deliberations are here on the record. So your deliberations will be part of the record. And I'm pretty sure that the state attorney who will be here tomorrow has, the judge and the parties will attempt to make this kind of chronological for you, so you can say, okay, allegation 1, did they prove it? Allegation 2, did they prove it? Allegation 3. And as you go through each of those, and Ms. Ryan, who will be the state's attorney tomorrow, will hand out to the judge, who will hand to you, proposed findings of fact and conclusions of law. So you will go through there, and the document will say, this is what I believe I have proven. And then you will go through as a group, and you will say, in discussing it in a public forum, did they prove this allegation? And basically, if somebody says, I'd like to make a motion that the state has proven this allegation, then somebody seconds it, then you discuss it, and sometimes that's real quick and sometimes it's not, because there may be several people that have a different idea from the other. You know, half of you may think one thing and the other half may think another. So that's when it gets kind of, you know, interesting at times, because you start discussing this in the open debate in front of everybody, and you come to a conclusion. So you'll do that for each allegation. The judge, again, will be there to guide you. If you have questions at that point, you have to go through the judge. You can't ask any of the attorneys. You can't ask John or anybody. If you have a question at that point in deliberations, you have to go, obviously, to the judge, who will give you guidance. After you've gone through whatever all the allegations and determined whether or not that you have proven, or the state has proven them by preponderance of the evidence, then you will do what's called conclusions of law. So conclusions of law come after findings of fact. These are the facts that we found, and based on these facts, were any laws violated? And so you will have a proposed, you'll have the notice of hearing and charges, which list the law that the state alleges was violated, and you'll have proposed findings of fact, and then you'll go through and say, okay, well, we found that they didn't meet that allegation. The state didn't prove that one, so there's no law that was violated. They did prove allegation number 2. What law did that violate? And that's where, in conclusions of law, that you determine what statute was violated. Again, that will be that's in the documents that you will have. Some respondents, especially respondents with attorneys, bring their own proposed findings of fact and conclusions of law. I don't know that this is going to happen tomorrow, but it could. And so, you know, you've got to weigh all the evidence. Yes, sir.
Back to when we deliberate on each of the charges.
It's majority. Yes. So majority carries. And once you weigh all the evidence and get the conclusions of law, then the next step is determining if the state didn't prove any of the allegations, the next step's easy. It's over, you know, that it is what it is. If the state proved all of its allegations or part of its allegations, then you deliberate on imposing civil penalties or any other discipline that's authorized by law. Those are established in the statutes and the rules, and of course will be available. Yes, sir.
If there are any penalties, it's going to be based off of our policies in our book, for disciplinary
yes,
action.
whatever
Okay.
whatever policies, regs that you have established. I see those right there. I'm assuming there's a range of, and you can debate and deliberate about the range, and that sometimes happens. Somebody will propose X $100 and somebody will say, no, I think they needs to go to the maximum, and then they'll debate about that. And it's just like the findings of fact, whether or not there's a debate and whether or not there's consensus as to what to impose. And so you will go through that process. Again, the judge will be here. You know, she will, Judge Collier is a very active judge. She will be giving a lot of guidance for you, and so she understands it's been a long time since the A&E Board has had a formal hearing, and so you know, she will be prepared for that. After all that is done, after your decisions have made, after you've decided what as far as the findings of fact, after you have done the conclusions of law, and after you have debated whether or decided whether or not there's any civil penalties or any other type of disciplinary action to take, the last thing that you have to do is, on the record, you have to give a policy statement. And the policy statement is, this is why we did this. And it can't be, you will have a proposed policy statement in the findings of fact, but you don't have to adopt it. That's your policy statement. You may read it and go, yes, this is exactly why we did this. But but you have to come to a determination that the reason we took this action is because the health, welfare, and safety of the citizens of the state of Tennessee demanded it. We hold our licensees to a higher, whatever, that sort of language. And if there's no findings of fault or violations of law, then the policy statement is the allegations weren't proven. So that's pretty simple. But so you will have the opportunity to make that determination. And the important thing to remember is, if a case ever gets appealed, the Chancery Court here in Davidson County that hears all of our appeals are very slow to overturn boards, administrative hearing, administrative programs, administrative hearings, because they're not, you are the ones that are here, and you are the ones designated by statute to determine conduct in the license and of your licensees as it relates to the statutes and the policies and the regulations. The one thing that will get a case overturned is if a penalty is not backed up by a finding of fact, meaning if it looks arbitrary. So if you penalize somebody, make sure that it matches up with the finding of fact in the allegation. That, if you're going to say somebody did this, make sure on the record it's clear that you determined that whatever they did, you found by preponderance of the evidence, and accordingly you are exacting this penalty because of it. That's the one thing that gets cases overturned, is when something seems, well, that's not backed up by the record, or the evidence doesn't show that they, clearly articulated that was the reason for the penalty. So, Tony, do you have anything else to add?
I would just take a couple minutes just to add from my experiences. Good advice as to how to work is that in this scenario you kind of have group dynamics working. So when it's all said and done and you've heard the testimony, the judge will kind of read some instructions, and she'll basically say, well, now you just need to make a determination as to what are the facts that you heard, what are the conclusions of law, and what are the penalties. And then that's when the board starts discussing, and that could last anywhere between 30 minutes, and I've seen it take up to 6 hours, just on the facts alone. And because what has to happen is the board as a group has to make a motion as to what are the facts. From everything you heard, what are the facts that are going to go into the order? Because some people want to skip the facts and just say they're in violation. Let's just say that. And then let's go back to the facts. And the judge won't let you do that. She'll say, no, you got to go back to the facts. So usually what happens is that the attorneys are allowed to present proposed findings of facts, which is, this is my suggestion as to the facts that I just proved before you. And the boards are clear to say, somebody can say, like, oh, no, I agree. Like 1 through 10, this is fine. This is sufficient. I make a motion that we adopt 1 through 10, Or somebody will say, well, I think 1 through 5 is good. 6 and 7, I don't think they proved that. And then 8, 9, and 10 is good. So we do a motion to do that, I've seen some boards do it easy like that. I've seen, if there's another attorney on the other side, they may have a competing facts that they can present also. So I've seen it where they've used those things, or they've completely scrapped it and said, let's go on our own. But the difficult point is that there needs to be some discussion as to what are the facts, and then there's generally a motion made as to these are the facts, and it's fact number 1 through however many you have. And those are all the important facts. And then you get back to, based on those facts that we've adopted, is there a violation of the law? If so, what are the violations under the specific statutes or rules? And that'll be in the charging document. You can use that as kind of guidance, but it's not proof. And then if they violated these laws, what are the civil penalties, if any, or suspension, revocation, etc., that we would do? All of this has to be agreed on by the board, and that's usually what we end up seeing, is that there's usually kind of like a dividing line amongst 4 people here, 6 people over there, and they're kind of going back and forth, and it's all good discussion. But I think I've heard somebody explain that really it's like taking, you're trying to take all this information and put it in a big filter and having something kind of come out the end of a little bit. You're getting a lot of information, and then in the end, you're just trying to filter it out to what is the relevant facts of this case to see whether or not there's a violation here. So going forward, I think that's the important thing. So if coming up with the facts, what are the actual facts of this case, is really important tomorrow, I would recommend that when you're hearing testimony tomorrow, that you're taking notes based on, I think that this is a fact. I think that this witness has good testimony, and I do believe them that this is a fact. Or you could say like, oh, well, now that I've heard the other side's witness, I don't believe that's a fact anymore, so that you can list these relevant facts. You know, and relevant facts are, you know, this person was licensed on this day or whatnot, and then, you know, you just kind of go forward from there. You know, witness said they saw X, Y, and Z. I believe them, they saw X, Y, and Z, and whatnot. So I would recommend tomorrow that going through there that you're taking notes as to what are the relevant facts, so that when you have discussion, you'll have some notes that you can refer back to. And it is important that when you're making determinations on the violation of the law, if you find that you feel that there are violations of law, that those are being made off of the facts presented during the case. And those facts can be through the testimony of the witnesses, by questions that were asked by the attorneys for either side, or the questions that the judge lets you ask any of those witnesses. But you keep it within that box. That way nobody can say that we're trying to hold somebody in violation for facts that were not presented at this case. Such as like, well, I know from my experience that you must have done X, Y, and Z because of whatnot, and you really didn't have a way of making that determination, so. That's
I have one question. Will the court reporter be recording our deliberations as well? Okay, so we
person
need to
will be.
speak in order based on Robert's recognition of us.
I don't know that I'll be recognizing you. It'll be the
Okay.
judge. It'll be,
Okay.
I mean, the judge kind of becomes the chairman, right? Or does she turn it over back over?
She
to
will
the
turn it over to you at the end of the proof. They will say, okay, Mr. Chairman, now your job is to take charge of the board, and we need you to make findings of facts and conclusions of law. And so, and it's really good because the judge can explain it to you, just kind of like how I did. She can go through a good explanation and kind of do a pause with you all. Is Mary Call here tomorrow or whatnot? Yeah. So they can, but there will be a court reporter, so, you know, she'll be, that person, he or she will be recording everything.
And everything is going to be videotaped as well, correct? Okay.
We don't, well, legal doesn't dictate that they be videoed, but if the board videotapes their meetings, then yes, it would be. Two more things that I thought of and that are very important. When you take a break, it's very important that you don't discuss it. Violate the Open Meetings Act, and that could potentially poison the water, so to speak. And if by chance, when the respondent appears, standard is a conflict of interest arises when you, as a member of the board, say, I can't fairly and impartially make a decision on this. If you say that to yourself, then you need to consider the appropriate action would be a recusal. Just because you know a person doesn't mean that you can't make a fair and that's your decision to make. I don't know if any of you will know the individual. Not uncommon, if especially, how many licensees are there total in the board? How much?
20,000.
20,000.
Yeah, that's pretty, yeah. And that's combined, right? Okay, so, yeah, that's bigger than I thought, sorry. You may or may not know the person, but you have to ask yourself that question. Can I fairly and impartially make a decision, or do I need to be safe and recuse myself? And then that's your decision to make. We can't tell you that. Yes, sir, I'm sorry.
At the beginning, when we're aware that we have a
Correct.
knowledge of the.
Yeah. No, I've seen, as long as you don't participate in the proceeding, you don't necessarily have to leave your seat. As long as you don't deliberate, as long as you don't ask questions, the judge may, I guess that she would make a recommendation on that, but I don't necessarily think you have to get up and leave the room. You just can't participate in the process. Only if the meeting that you had causes you to believe that I can't fairly and impartially make a decision.
Having met someone does not constitute a need to recuse, okay.
And the judge should tell you tomorrow, that should be part of the judge's process, is they'll say, you have before you this matter, whatnot, and the respondent here, does any of the board members know the respondent or have any knowledge regarding this case after you look at the document that you need to, and she'll ask you to disclose, and you may say yes, and then she'll go through the process of impartiality and
Yeah,
whatnot.
she'll guide you and ask you on the record.
Yeah.
Yes, sir. Okay, that probably would, that's your call, that's your decision to make, that's the board's decision to make. It's probably a good practice, because you did review the process. So, but that typically, that is what happens.
Putting in the water seems to make sense.
Yes.
So what I should do is come here when it opens up, recuse myself?
On the record that you have reviewed this matter previously, and because of the knowledge that you gain, you think it would be appropriate to after you you need to put on the record that you're recusing yourself, so that there's but after that, you don't necessarily have to get up, as long as you don't participate.
Well, and the judge may say, and the judge may, may have a way that they individually do that. Each judges kind of do them differently.
Yeah, we
So-
work with 17 or so administrative law judges, and they have 17 different ways. Exactly what to do, but that would be up to you.
Hey, and another thing is, and this is on counting votes, right? So we've got 9 voting members. Absentee in some form, in some things, if you don't have everybody there, it changes your.
Said majority.
Yeah, but majority of present or majority of members?
Majority present.
Okay.
Yeah, if you got 7 here, then
It's 4-3.
it takes 4 to carry.
Associate members, no. They can listen to the case. Quick question.
Yes, sir.
I know once you start, let's say if you had to, you have emergency, you had to go to restroom, you just walked out or what?
Ask the judge, or ask the
How do you-
judge or the chairman to say, can we take, I've got an emergency phone call that I need to take. Can we take? Had to leave, obviously, we could still proceed if we have a quorum, but we would need to put on the record that that Commissioner Lim is.
You'll have to get permission to leave. That happened to me once at a hearing where one member got up, they had to go to the restroom, there was testimony going on, and when he went out there, they said that person cannot come back in this room, and we had to send a paralegal out and had to come and get all of their belongings and items because the judge wouldn't let them back in the room. So they just, and that was kind of a quirky incident, but it's real easy just to say, can we take a recess, and they'll stop everything, 5-10 minutes, no big deal. Same thing for lunch. Some of these judges will let you go all day long and not make first peep out of lunch, and everybody's thinking, when are we going to take lunch? Well, sometimes the judges are like, I'm not in charge of lunch. I can go all day long. So sometimes it has to be like board members or saying like, can we recess and can we discuss lunch?
Call your break for lunch.
Good.
She will break.
Less coffee tomorrow morning.
Okay.
One last thing, these microphones, obviously, if you have a question or need to speak, just like in a board meeting, make sure you're being heard so the court reporter can, because the court reporter will say, I'm sorry, I can't hear you. Can you repeat yourself? So just make sure you lean up and that you're clearly heard. So
I'll take note.
I will.
The attorney and Mr. Cawthron will be here. The respondent, and if they have an attorney, will be there. If there's anywhere, there may be room up here, and that's fine for everybody to sit. Typically, I've seen people, just sit on the front row. Staff members sit on the front row. Or sometimes they kind of monitor things from the back. So wherever you want to. Well, I hope this, gives you an overview, because having not done a hearing in a while, I know that's, and then, all of a sudden, even boards that do a lot of hearings end up taking, it takes doing a few before you find your groove. So, you don't be discouraged if it's, kind of disjointed at times. That's not uncommon. But the judge will definitely guide you and answer your questions. So, yes, sir.
Selfish question, just as a matter of information or point of information, sorry. So let's say the hearing concludes and we've made comments and things to the effect that the judge then makes a decision on, or we make a decision on what action to take. If the respondent, I guess anyone can file a lawsuit against the board or individuals on the board, right? But if so, are we protected by the state legal counsel?
As long as your actions are not arbitrary and capricious or outside the bounds of what your legal duty is here, which it will not be, yes, you will be. The state attorney general will provide defense counsel for a board or a board member that is saying. I've never seen somebody sue a individual board member before, but yes, if you took action that was so beyond the pale of any reasonable expectation of your role and responsibility as a duly appointed board member, then maybe, not maybe, but yeah, the state would probably would not defend you. But in this setting, that is something I would not worry about.
Do we gather in this room, or do we need to be outside and then come in?
No, you
Okay.
can gather here. Is the hearing in 1B? Is it here? Okay, yeah. You'll just come in and gather like you normally do. So.
Excuse from the
All right, anything else?
Well, one thing, an observation, that we've done one hearing in 9 years. So we don't do a lot of them.
No.
And the last time the judge and they were over there on that side. Everybody else was over here. So may not be.
We will, we'll configure it. I've seen the judge sit on the end and just kind of, next to the court reporter and the witness over there. We make people on the flanks may have to scoot in just a little bit, but we'll make it work. So, thank you
Very much.
Thank you very much.
Appreciate it.
Very informative.
And Tony and I'll probably be. Luck and thank you.
Thank you. All right. Our next item is the director's report. John?
Okay, I have a few comments for you before we go into the complaint report.
Page, please, sir.
Well, the complaint data is on page 112. But before I get to that, some information about national council meetings. Rick Thompson, Frank Wagster, Jerry Headley, and I attended the NCARB annual meeting in New Orleans in June. Robert Campbell, Ricky Bursai, Stephen King, Philip Lim, Ellery, and I are going to attend the NCAAS annual meeting in Williamsburg next week. We did have to reduce the number of attendees for that to receive approval to travel for that meeting. A request has been submitted for Bill Lockwood, Jerry Headley, and I to attend the CLARB annual meeting in New Orleans on September 17th through the 19th, and the CIDQ annual meeting is scheduled for November 13th and 14th in Atlanta, and we're waiting to receive the final agenda for that before we submit that for approval. Some administrative issues. Our new licensing system, which has been dubbed CORE, is still scheduled to go live on September 9th. There have been a few delays this month, I think unexpected delays, but we're being told it's still on, still anticipated that it's going to go live on September 9th. We have tested the online renewal system, which is a great improvement over the system that we're currently using, mainly because there's not going to be any additional convenience fees or service charges. So right now you have to pay, if you renew online, you pay like $144.84 or something like that. There's an extra fee added on that goes to the vendor. No, you don't have to. You can still mail it in. And even with this system, you have the option of mailing it in. But the great thing about this system is there's not going to be any additional fees. So when you renew, it'll just be $140. Nothing's going to be tacked on to that. So that's a big advantage, and I think we'll see an increase in our online adoption rate as a result, because if it was me, I would rather mail it in than pay that extra fee myself. So I'm glad that's going away. But that has been occupying a lot of our time because it requires a lot of testing when you're implementing a new system like that. So we'll be happy when that is finally implemented. At our sunset hearing on June 17th, the Joint Government Operations Subcommittee did recommend an extension of the board for 4 years. That'll take us to June 30th, 2020. They did focus on reserve balances, and they noticed ours, of course, is rather large. Not the largest of those that were being reviewed, but we do have a large reserve balance. And they're urging all boards and commissions to consider reducing fees if they have a significant reserve. That's also a priority of the administration. So just FYI, that's something that they're always looking at. Right, yeah, registration fees, correct. Yeah. We will be sending out grant letters, requesting grant proposals very soon. I'm hoping Friday or Monday can get those sent out. Also, a reminder, be sure to complete your Title VI training by August 21st. Several have already submitted that. I think so far Frank is the only one that scored a 100 on his exam. Yeah, so good job, Frank.
Did you not get mine?
I don't think I did, but I'll have to check
Not
back.
automatically record our names and send you a list or anything?
No, you have to send the certificate to me, like print it out, scan it, and email it. Yeah.
You were probably on Grindr and not on the right Twitter.
Oh, no.
Okay. You may have noticed the board newsletter still has not gone out because we're still waiting on some of our rules to be filed with the Secretary of State. I really wanted to get all of our rule changes in that newsletter, so.
They are with the Attorney General's office, and they have been for about a month and a half now. So I keep reminding them to hurry it along, but still waiting.
Hopefully that will happen very soon. If not, I may just take the rules out of the newsletter and just go with it. Let's see. I think that's all I had. Oh, yeah, one. Well, we can talk about that when we do the October meeting agenda. So, but yeah, we do have a hotel for Chattanooga. You have open complaints on page 112. As I mentioned earlier, this is just a snapshot. Complaints opened as of August the 5th. Our percent on time, you'll see, is 100%, so that's good. Yay. And I think that's it for my director's report. Yes, we don't have any other reports for you, so. We'll have the final report for the fiscal year ending in June 30th at the October meeting like we usually do, because they still haven't completely closed the fiscal year yet. So that's when you'll receive that information.
Quick thing before, I'll take a quick chairman's thing before we go into engineering report, Hal. I'm not exactly sure what happened with this informal thing that we just had. I don't know where it went upside down, inside out, or exactly what did happen. But we all got to get better at that. The guy that stood in front of us, that's a perfect example of why we have license. He had no idea about 70% of things that he was talking about. And that's what we're here to do. So we've all got to improve on how we communicate, how we put that through, and what we end up doing, because we basically took our stinger away before we ever got started. And I, again, don't know how that happened, but again, we just got to get better. So Hal?
Just a question on that. So if
I didn't quite.
With you, the way it reads, it's the fact that there was a said to be incomplete, but they didn't have a standard.
I can look into other things we can do. I mean, it was my understanding that the finalized plan was acceptable based on what I got back, but I'm not an engineer or an architect. When I see those plans, I'm not going to catch anything. So I think I'll look into anything we make sure, see if there are any avenues we haven't foregone. I'd have to look into that and get back to you. Again,
double jeopardy wouldn't apply here if there was a new complaint on the same set of.
I would have to do some looking because you have already all seen it to see what could be done there, and I can get back to you in the October meeting about potential other avenues.
Is this letter going to the other states that he's registered in?
Definitely copy them. There's nothing preventing us from doing
Is
that.
that a problem, John?
There's no problem with that.
All right.
Should we continue with that?
Well, yeah, it shouldn't have any bearing on any other action. I will draft the letter, and then I'll send it out to the board members to review and see. And I mean, maybe this was a miscommunication we had. I believed the informal conference was to be before the full board. That's how I interpreted it as being. I'd never done an informal conference. I didn't even know we had them in any way other than the full board. So maybe this is just something that we need to, or I need to be more clear on as we go forward.
And this board's unique, I think, in doing informal conferences the way we typically do them. Accountancy board, probably they're the most similar in the way they review complaints. They have what's called a probable cause committee that I think conducts those types of reviews, or do it a little differently rather than just having one board member review it. I've actually floated the idea of having a probable cause committee in the past, and it just might be something to consider, because even if you have one board member review it, they may miss things that someone in another profession would catch.
I mean, he did all of it, so one board member who specialized in one wouldn't necessarily catch everything. So that's something John and I had mentioned, just to think about to improve our process.
Might be something for the October retreat to discuss, maybe.
So, just to summarize, I think what we're interested in is legally, if this complaint was about the preliminary drawings and that's being handled by the letter, can we now have a new complaint about the final drawings in incompetence? And the other question I think that came up was, this may be unrelated, but what Mr. Green said when he talked about it was Frank's decision whether to recuse himself or not, and him being the one who reviewed that case makes me wonder whether the fact that we had an informal conference, does that really mean we can't pursue a complaint, or is it all up to us about whether we feel like we can fairly judge things?
Let's get to the point first on that, to see if there's anything that we can go forward with, and then we will decide what our appropriate path is going down. Hal, go do our engineering committee report,
real
please.
quick, Mr. Chair. For the board, we had a visitor this morning from the Tennessee Department. The bar of our level of professionalism within their department. The only other thing of note, and I'm assuming we need board approval for ABET visits by engineering board members. Would that be correct, John? Okay, so it was determined, and everyone's familiar with ABET approval process and cycle, I'm sure, every 5 years. And so Christian Brothers is due in November, and Ricky Bursai is going to be visiting and observing that process. Laura Reinbold will be observing the Lipscomb University ABET process. I will be observing the TSU ABET process. So, and I guess with that, our committee makes a motion to approve attendance and any expenses incurred by the board members for those respective activities.
Okay, so it comes from a committee and doesn't need a second. Is there any discussion? Favor say aye.
Aye.
Opposed? Are there any other travel things that we have to ratify?
Well, I think Hal is speaking
in
September, so you may want to
Go ahead and do that
authorize
now
him for
while
that
we're-
purpose.
I'm supposed to attend. I am attending the. Is it just me or is John coming too? Oh, blah.
To Clarb.
How are you?
Do we need to vote on that too?
No,
Clarb.
that's already been approved. That's in our travel.
It's in our
plan.
travel.
So I am.
Mr. Chairman, can I make a motion for you?
Sure, go ahead.
This motion to approve Mr. Howard trip to travel to TSBA annual. Honorable Speaker.
Okay.
I'll second that.
Second, any discussion? All in favor say aye.
Aye.
Now, that took care of authorization of travel and speakers at the very end too, since we were in the middle of that. Okay, so, engineering committee report, that's done?
That's done, yes,
Good.
sir.
Unfinished business, John, we got action items, and I think that's on page 113, maybe?
The architect committee.
Well, that's not on my little agenda.
It's not?
No?
It's not on the
Oh, you
agenda?
must have the
Yeah,
one
you're right.
before the revised one.
Yeah, well, I didn't get that one.
President doesn't get things like
I basically ignore architects in most everything I do anyway, so why shouldn't I on the agenda? Okay, go ahead, architects.
that. No reason.
Very, very quickly, we met this morning. We had, you don't have it on there, Robert, but we reviewed application and audits, and we just had a discussion regarding an applicant who finally did meet the NCARB requirements, and we approved him. And then the second item, we discussed the IDP experience portfolio documentation method. That was something that came out of NCARB when we were in New Orleans. And basically, it's for broadly experienced interns who have not done their IDP so they can sit for the exam. So they're going to develop the concept, and we are in agreement with the concept. And that's all I got.
Questions for the architect committee? Thank you all very much. Nothing that we need to vote on as a board, because you all took care of it as a committee, correct? Okay. All right, I'm sorry, John, action items, please.
All right, page 113 on your iPads. You have the action items from the last meeting. I have obtained, under my name, the number of enrolled seniors from each school, except for 2. So I'm going to send that out to the engineer committee once it's complete. I have yet to hear from a couple of them. We have yet to talk about the revisions to humanities, social sciences criteria, but we have prepared some proposed revisions to that policy. I did respond to Mr. Tomasello, and I think Ellery has addressed all of the issues under her name. And I get now might be a good time for her to address her revised policy on QBS as it applies to public schools, which is.
Do I need to discuss the CLARB sentence?
We didn't talk about that at the committee meeting, so.
Oh, is that supposed to be in the committee meeting?
Yeah.
Okay, well,
We haven't talked about it yet.
we can skip that for now.
Okay. But her revised policy on public schools is on page 120.
Yes, and what I did is on the second page, so I guess 121, the third paragraph down, it starts with similarly. I just added some language in there addressing that issue as well, which just further bolsters my opinion that
It's the third
schools
paragraph
still
from the
have to
bottom.
abide by QBS.
Yeah, third paragraph from the bottom was added.
There is no action. That was just something that Mr. Bursai had brought up that had been left out of that opinion. So I was just adding it and giving you the final complete opinion.
And another opinion she has revisited is the opinion discipline of a non-registrant who adds a title to plans. I guess we can go over that one now too.
What page is that on?
Let's see. Let me pull it up. That starts on page 105. This was regarding the owner who added the title PE to plans prepared by a non-registrant.
Yeah, so I went back and looked at this. 2 main issues I looked at. I looked at the charge of forgery, and there are 3 elements to forgery. Just to go through it briefly again. The first one is to alter. The second is you have to alter a writing. And the third is with the intent to harm or defraud. And the issue at the last meeting was the third, which is always the hardest to determine what the intent was in altering this title block. And so the issue is if he intended to defraud or harm another, then it would constitute forgery. And so I believe the facts are kind of split. I think you could find it either way. I think one of the facts that leans towards maybe he did have the intent to defraud is that he did state that he was just trying to hurry the process along. And more importantly, I think, is that he didn't just add that the non-registrant was registered in Tennessee, he added 5 other states as well. So that is a fact I emphasized that could lead towards intent to defraud or harm another. Again, that is a crime, and so that's something that's outside of this board's jurisdiction, but I would still be fine with the recommendation if the board wants to refer this matter to the local DA. The second issue was an issue we discussed at length the last meeting, was this could be considered the unlicensed practice of engineering for altering a title block. I went back and looked through our rules and our statutes, did some more research. I'm still not convinced it is, and one of the things that I noted is that our rules discuss a lot about stamps and seals, but there is no mention of anything about a title block. So I And still, just my personal opinion, I don't feel like a title block, I mean, it's definitely a forgery, but is it really the practice of engineering if you're just putting someone's name on something? So I think maybe in the October meeting, when we're addressing rules, we might want to consider adding something about a title block that could give us some potentially enforcement power in that instance, because our rules don't address it at all. So I would find it very difficult to argue before a judge that something we don't even address is considered the practice of engineering.
And on that, so
yes, the adding of it, he's altering this writing, this site plan, which in the legal definition is considered a writing, that someone else made with this intent, so that all of it would constitute forgery, like every alteration he did.
So back to the title block issue,
No, what happened here, which is why the unlicensed issue is a little more difficult, is that the non-registrant who prepared the site plan just did this preliminarily, and he gave this to his friend he was doing this for, the owner of the land. And the owner put the non-registrant's name on it, saying he was licensed. The owner himself didn't say that he was licensed, because that would definitely constitute the unlicensed practice, but he put someone else's name on it, and that creates the problem.
so and back to the potential.
Wait, sorry, I didn't hear all of that.
I'm sorry. I don't want to overcomplicate. So we're going to talk about it. It's going to be on the agenda for the rules discussion at the
Yeah,
retreat,
if
right?
the board wishes, that was
Okay, so
based on my review. Since there is nothing there, maybe that's something we should consider,
Right.
especially in light of this case.
I understand, my understanding of what you're saying, because we do not actually specify drawing sheet, title block, anything in that statute, that your opinion is that is not a legal document.
That's not my opinion is not that that's not a legal document. It's my opinion is adding someone's name, I don't believe constitutes the practice of engineering. And I don't think just adding a name on a document is enough to convince a judge that that person is practicing engineering.
Well, then, am I understanding that maybe, or not maybe, we're going to need to address title block and/or drawing sheet somewhere in our statute so it's clear that that is a legal document? Is that what I'm understanding?
I think addressing title blocks and drawing sheets in the rules would help an argument that it is the practicing of engineering if you're adding these on to drawings. But right now, based on the laws and rules I have, if it was me arguing before a judge, I feel like I don't have a lot of ground to stand on.
Let's attack that in October.
Yeah.
Because I think it's gonna have some other prongs to it as well, as far as alteration of what we consider and what we consider that alteration to be, so.
So, one last, so your recommendation is that this get referred to a district attorney in that area?
Yes.
Forgery.
Yes, for the crime of forgery, and they'll review it, and they're the proper jurisdiction for a forgery claim.
Pleasure of the board.
I move that I make a motion that we accept the recommendation of our legal counsel and have this referred to the district attorney's office in that immediate area for further review and possible prosecution.
I have a second.
A second.
Any discussion? All those in favor say aye.
Aye.
Opposed? And the ayes have it. All right. Was it, what?
Not quite done with action items.
What page is it? I lost it.
113 is the action items. And we did submit the legislative proposals regarding the comedy statute and the retention of exam credit. My understanding that the comedy statute one, I think, is one that the department's interested in. I don't think the exam retention proposal made the cut, so. But it's still got a long ways to go before it would make it into the governor's package. So at this point, we can't say if the comedy statute revision will be in the governor's proposals or not. I guess Rick Thompson's still working on Appendix E for the reference manual, right, Rick?
Yes,
Okay, still working on that.
Yeah, thank you.
And we'll be discussing the reference manual revisions again in October, of course, when the Publications Committee meets again. I think that's it for the action items. If you want me to just move into QBS, all right. And of course, this applies to the schools issue as well. But after the last meeting, Mr. Campbell sent me an email regarding FAQ number 3. Does TCA 124107A encompass studies and other services that do not involve the preparation of sealed plans? Oh, I'm sorry, this was not from Mr. Campbell. This was from the state architect's office. Sorry, you're a later one, sorry. Yeah. And the revised language that was adopted says any study or service that requires professional architectural engineering or landscape architectural services and expertise that requires the seal of a registrant, or if these professional services are offered by the proposer, would fall under the scope of the statute. And I think where a lot of confusion has arisen regarding this question is in regard to planning services, how this applies to planning services. And the state architect was asking, should this response be revised to distinguish between soliciting for professional services, which requires an RFQ, and soliciting for services with an RFP to which a professional might respond? Because I guess there's some perception out there that if you're an architect, you can never respond to an RFP, even if the services are not necessarily architectural services. That's the way some approach it. So he was asking if maybe that it needs to be clarified regarding planning services or other services that are not specifically. Okay. Well, I think some registrants have the impression that if they're a registered architect, engineer, landscape architect, they can never submit a response to an RFP, only to an RFQ, because if they're bound to the QBS restrictions in the law just by virtue of being an architect or an engineer, regardless of what services they're offering. Seems to be the perception, I think, among some, that they're prohibited from submitting a bid even if it's not strictly architectural services or engineering.
So like an engineer who's doing an
Yeah.
situation where it doesn't require a standard.
Right. Yeah.
This came out from the master plan.
Okay.
That could be bid, is what you're saying? Are we confusing that with the spirit?
Well, I think there's some differing opinions on that.
No, I didn't raise my thing. I'm out of order.
You can finish that thought.
Well, if I'm going to that thing in September, I want to make sure I'm clear of what our position is.
But it depends on if architecture or engineering is a core component of the services offered, I think. Or really.
My question, and I'm saying this because of some things I know. Services.
Frank?
Yeah, I think this came up, John, if you can remind me, but it seems like Shelby County was asking for master planning from proposals. And, the way it was written, it's the way RFPs are written for architectural engineering services, first of all, even though it doesn't say that. And the other thing that concerned me about that particular one is there are references in there to professional services. Now, I think it probably could be rewritten without those in there, and I would probably be more comfortable with it, but, basically they're looking for something that I think probably doesn't require a seal. But there were references in there that indicated they want professionals and they want somebody capable of doing that. And so I think that came up I think I may have brought it up, but I think that came from other architects in Shelby County area also, that they were concerned that, and they were asking for cost proposals, just flat out. Ricky, I don't know if you're familiar with that, but anyway, that was, and again, there's no formal response. I just looked at that and, kind of told John what I thought about it. But I think that's where the question was raised, is, if there's a proposal, or RFP there, that the implication is that you're supposed to be registered professionals, whether or not it requires a seal. Are we, going against our QBS provisions by taking part in that?
I mean,
I think the answer is no, but it needs to be
answer's-
written correctly.
Right. Well, I mean, I think you got two problems here. I think your proposal's probably written incorrectly for one thing. So if the county comes up and asks us, there's an RFP or RF whatever that comes out and says, we need somebody to prune the trees, and you're an architect and you're really good at pruning trees, does that require you to have a seal? I mean, can you not put a price proposal on there? Just because you're an architect or an engineer doesn't mean that you can't put a price on something that does not require seal, and that does not require seal. If they've written this such that there are professional services required of this planning document, if there are some sort of planning forecast, and I can't imagine almost any planning document, with the exception of traffic generation planning, because they all make this stuff up anyway on these planning documents, requires professional seal, professional services. But if it's something that in that planning document requires you to practice architecture, I mean, you've got to go out and do a evaluation of all the structures within a 10-mile radius and how they're going to be rehabbed and cost, then yes, it's professional services, and you would be bound then by that. But if it's just tell them what you think is going to happen 5 years from now, then yeah,
They were asking for things like that, but it didn't require a seal.
But that's professional services, my opinion. Okay, Rick.
That's what I remember that we've, in terms of answers we've given people who have been to the meetings, is that it depends. That's our answer, it depends. If the master plan doesn't require professional design services, then it doesn't apply then QBS rule doesn't apply. But if the master plan requires professional design services, and that's not necessarily a stamped plan, it could be a report that talks about, campus steam system or chill water system or whatever, those are in master plans, then QBS would apply. That's what I remember our answer has been. It depends.
This included floor planning and cost estimating.
See, I think that's an architectural service. Walking down the sidewalk right now is not going to do it.
Yeah, I guess the big question is, or what raises the question
Well, he
is,
may be an architect. I forgot.
would you have to seal the plans? And the answer, and their proposal was, no, I don't think so. But it's doing the same thing. It's like doing preliminary planning that you don't seal the preliminary plans. Anyway, that's where the question came up.
How?
Did we already cover activities that may require engineering or architectural or LA or interior design judgment in the scope of work? Has that ever come up? Because, okay. And the concern I know that we've had all along, the slippery slope aspect of it, is that depending on how the owner packages a request of whatever type, I'm fearful that, again, that entities will work or try to work or circumvent this if they think price is most important. So I just wondered, we didn't talk about the use of engineering or any professional service judgment, did we? We kind of delineated by, if it requires a seal, that was the threshold. So is that our position then? Anything requiring a seal?
Big question 3.
Right.
Yeah.
Right.
What Frank was saying, the project you're describing, I mean, that didn't require a seal, right? So.
Can the owner qualify that? Can the owner of a publicly funded project be the decider on what requires sealing and what does not?
See, I think that's the question.
And I understand, and I think in the spirit of the QBS, I think we have to continue to say that if public health and safety is paramount in whatever the request is and whatever form it takes, and the owner, or by virtue of the definition of the project under customary practice, requires sealing, then QBS applies. So a publicly funded study that may result in ultimate design, to me, in that regard, if we use that definition, would fall under QBS. What do you think as a public agent?
Well, I've already said I think we get hung up on professional design services. We also get hung up on our practice and thinking that our practice is limited to what we have to put a seal on. The practice of engineering and architecture and landscape architecture and interior design, we don't define it, but we all know what it is. Well, our law doesn't define it, but we know what it is. And if a government asks for something that requires that practice, it ought to be a part of QBS. And the city or county or state doesn't know that. So it falls on us. And it's difficult for us, I know, but that's...
So we've defined it. Not the
well,
practice of it, but the use of a seal as it relates to QBS.
I'm saying, though, that I don't agree with that.
Oh, okay.
I'm saying that there are things that don't require a seal that are the practice of engineering.
So would that be a QBS?
Yes.
Okay. Yeah, I agree. I agree with that. Is that our position then?
But again, look at what our statement says. It says requires a seal or what? Or if the professional services are offered by the proposer. So in this case, there's probably something that does not require seal. It's a preliminary plan of some sort, whatever it is. So it may not require seal. However, the or part says if these professional services are offered. So if you're doing something as part of a study as a professional that is considered a professional service, then this does. If you're out pruning trees and it's not a professional service, we don't care. But if this is a professional service, if you're doing planning studies based on the square footage of a building or based on the duct system of a university, or heaven forbid, if you're trying to take the driving lanes down to 6.5 foot and put bike lanes everywhere else, that's considered a professional service.
I agree with that. I think we're wrong to tie QBS to simply what you stamp. It needs to be
But we
on.
didn't.
It needs, right, and it needs to be
It's
on
much
professional
simpler to do
services.
it that way, but it's
Right.
really not the right thing
It's
to do.
professional services.
We put that in this,
Yeah,
we put that
that's-
in.
That sounds good to
Good,
me.
good.
Well, if you're an A&E firm and you make a proposal, then do you write on there, you know, we're making this proposal, but we're not doing this as professionals?
I think you would.
I think that
Well,
adds to the
Isn't that what they're
confusion,
looking for?
I think it depends. If you're putting together floor
Because
plans.
if you don't say that, then the implication
Architectural
is
firm, yeah.
you're an architectural firm.
Yeah.
You're offering your service.
I think you've got to look at what they're asking for. If they're asking for floor plans that you put together that looks at fire ratings and building types and occupancy types, then you say, no, thank you. I'm not responding, or I'm responding without a price.
Right.
And say, because I can't
Yeah.
respond to the price
I agree with that.
with a price. I
I
mean,
mean, that's was pretty much what I was saying. Either we
Yeah.
don't respond or.
yeah. Now, if your study is just to count the students that walk by, then that doesn't take a registered architect to
Part of
do
it,
it.
but not the
If
whole
that's
thing.
all it is, I would have no problem with an architectural firm, like pruning the tree there.
Yeah, there are a lot of other aspects of what they were looking for in master plan, you know, demographic studies, on and on and on, traffic studies.
We ran into this in Moorestown where they're at. Part of an inspection service, like we've said before, that do not require an engineer, but inspectors on staff. And, you know, but there are parts of inspection that require engineering, so you just have to delineate that.
That would be a professional service, right?
Right, and that was what we discussed with them, that if
Was
it
that
ever
a
crossed
bid?
the line, then.
Was that a bid?
It was for just the inspection, but then we said if it ever crossed the line, then you have to, we can't.
Was that delineated in the contract? You're not-
All right, anything?
AC, is that
We
gonna
don't have
be
an
on
answer, but I'm sure
topic of,
that's.
yeah, okay, sure. Great.
Don't need to change number
What is
three.
professional service?
Do what?
Number three is okay.
I think we've got.
As
to-
worded.
Yeah, it would
Okay.
be the horse dick.
Very good. Okay, now the number 9, this is the one Mr. Campbell was asking about. He sent me an email. Is it permissible for a registrant to submit hourly rates and an estimate of man-hours required to complete a design project in response to a RFQ, RFP for a public project? The part in question is where it says, however, it is permissible to submit hourly rates if an estimate of man-hours is not provided. And then Robert sent me an email, this is like a few days after the board meeting. Is this correct in light of new FHWA Rule 23, blah, 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 which states price shall not be used as a factor in the evaluation, ranking, and selection phase? All price or cost-related items which include but are not limited to cost proposals, direct salaries, wage rates, indirect cost rates, and other direct costs are prohibited from being used as evaluation criteria. Feds are saying, no, you can't.
HWA
submit
just
that.
came out with part 17 of whatever part 17 means. There's a lot of auditing and all kinds of things. Because they've had this as whatever, it's not a rule, it's a clarification of a policy that they've actually had rulemaking, public hearing and notice. And the FHWA came out with this a month ago, I think. And I just know personally that TDOT is revising a lot of their policies and procedures, from consultant selection to how they audit people to how they ask based on this 17, and that's directly stated in there. So
And just as a point,
proposals or something. I mean, it's under a germane topic. Certainly is. Because I think before they had given people the flexibility to say yes, no, well, maybe, and now they've basically come out. Not consistent because we've said that it's okay to put,
Oh, okay, I got you.
Like that last sentence, or?
Why did
Like
you
it.
put that in the first place?
because at some point it was acceptable. I mean, people were asking for man hours.
That was as a starting point for negotiation, wasn't it?
Wasn't that based on the state architect's fee schedule?
I would prefer that. I think it's
Problem to cite the FHWA rule, though?
The reason I wouldn't, Hal, is because that's just specific for transportation. It may be different for what the state architect organization as large as TDOT and an organization like FHWA, when they typically come down with a rule, you will start to see
We might cite it in conversation, Casey.
All right, so we're striking that last sentence in number 9, and the only other revision is at the very end of the document. We added a sentence that the above responses should not be viewed as comprehensive, and registrants are urged to contact the board office for questions that are not addressed in this document. I think it was.
I was the one who said to Annie.
Want to make those two changes, you can entertain a motion, I suppose.
Motion?
Move to approve the recommendations as discussed.
Second.
Discussion?
Just a point of question here. Once we get all this thing out together, I think maybe we should reach out to TSPE or ACEC to help us share this information out. Is that suddenly September meeting? Are you going to talk a little bit about that?
I'm sure that'll be on.
Do a PowerPoint presentation? Yeah. Thank you.
We can have it there, yeah.
All those in favor?
Aye.
Opposed? Good deal. All right, we've gone through the formal hearing procedure. I'm sorry, John, were you done?
I'm done.
That's it on QBS. Committee assignments. Okay. First of all, Rick Thompson is going to be a standing member of all committees. Does that sound good? The only ones that we need to change, Frank Waxer will now be the chair of finance. That is,
Oh, we're downhill right
Spend the
now.
money, you heard John. We have too much money.
we keep that intact. Wilson Borden, who was the chair of nominations, we will need a new chair of nominations. So, do we have any volunteers to move on to that?
Philip Lamb.
Philip Lim sounds good. You're gonna be the chair.
Which one?
Nominations.
All of them.
Thank you. Yeah.
Susan, you're okay with grants to higher education? Laws and rules, Rick, you're in good shape with that? And then everybody and again, we'll find whoever our new body on laws and rules, okay? Publications, Steve, you good? Okay. You look like you are.
That didn't really come across as being enthusiastic. did it?
We could, like, knock
Well,
that-
you gotta finish out the reference manual
Yeah.
revision.
We don't have a finished product yet.
You'll get there. That's another reason to keep you there. Bill Lockwood, okay on licensure?
Sure.
The other members are good. And again, Philip's gonna be our nomination chair. Frank will be our finance chair. And we'll find, and Frank also continuing education. You good with that?
When we get the new public member, do we have any idea when that might be? Just whenever they get ready? As usual, okay.
Haven't heard anything yet.
We may make a couple changes depending on who the new public member is and what their expertise happens to be, and we may take some people off and on, right? So for right now, though, let's go ahead.
Yeah.
Juan, did you get all that?
I don't know whether you were joking or not, but
I was serious about that, on nominations, just on nominations.
Nomination committee.
I
Not
was
for
serious.
everything.
I was kidding about Rick being on every committee.
Rick is the one that needs to be on every committee.
No, I want to know.
I was kidding about that.
Yeah, you.
Okay, October meeting agenda.
On page 122 on your iPads, so draft agenda for our meeting in October in Chattanooga at UTC. Of course, we do have our meeting room arranged, still working on some details, of course. We do have our hotel selected, the Staybridge Suites on Carter Street in Chattanooga, which Mr. Lim will be happy to know serves complimentary breakfast.
Well, which
And
I know that because this, every time I go to Chattanooga, that's why I stay. It's 1300 Carter Street.
Okay, very good. So you're familiar with it?
Oh, yeah.
It's a nice hotel?
It's a one-star
It's a nice
hotel.
hotel.
Okay.
Well,
Yeah.
last two times
Only
I
the
went in,
best.
somebody cooked some kind of popcorn and then we evacuated the room for it.
I wanted to stay at the Econo Lodge, but anyways, that didn't
No.
work. Self-parking is only $3, but if you bring your pet, there's a fee, so. Anyway.
Rooms are by the hour too, just FYI.
Okay. I was gonna make a joke, but I'm gonna refrain. All right, so you'll see Wednesday, we start off at 1 o'clock. As in the past several years, we have all the different profession-specific committees meeting first, the interior design, landscape architect, and then the engineer committees. And then Thursday morning, 8 o'clock's a little early, but we have a busy day Thursday. We might could adjust that. Law and rules policies meets first, then grants, finance, publications, licensure outreach, continuing ed, then we have lunch, and at 1 is our meeting with engineering and interior design students and faculty, like we typically do, have some outreach activities at these events on university campuses. And then after that, it's, sort of open. We have board member trainings, the title here, but, we could fit some different things here. One thing I thought would be helpful would be a review of the recent U.S. Supreme Court case regarding the North Carolina State Board of Dental Examiners. I think many of you are familiar with that. See, basically, the Supreme Court, I should say, started with the FTC. Basically, sort of limited
Yeah, I can give you a
boards.
brief rundown now, though we'll discuss it in a lot more detail in October.
Yeah.
The Supreme Court found that the North Carolina Board of Dental Examiners was acting outside of their authority in certain disciplinary actions they were taking, and found that that board did not have enough state oversight. So that had some serious implications for that board. We'll discuss more details in October on how that would apply to our board and if there's anything we need to be concerned about. Their board is structured significantly differently than ours. So my initial thought is we don't need to, off the cuff, immediately change everything we're doing, but we'll just discuss it. And so the concerns the Supreme Court expressed for acting outside of the board's authority. So we all are aware of very recent and Supreme Court decision that has a lot of regulatory boards across the country a little nervous in talking about.
Okay, so that's Thursday for us. Of course, I think Rick Thompson has volunteered to have us over for a barbecue or something. Is that right, Rick? On Thursday night, I guess, or Wednesday night? Okay.
I thought you might
Thursday?
just take us to a public house or something Thursday night, just treat us.
Susie says
Wednesday
Thursday.
afternoons.
Susie says Thursday works better for her, I think.
Hey, John, actually, you start the meeting at 8 o'clock. It's 7 a.m. for me. It's too early, man. So it's 20 people, we're going to struggle. Abby? Can we start the meeting at 8:30, maybe?
8:30? Or,
14 hours ahead of
You
you.
have to remember also, you've got the traffic from the people that work there that we're gonna have to deal with
True.
as well. Okay?
Yeah, I mean, you had people going driving to school and everything.
Right.
But the,
Well, and parking at UTC is gonna be a bear.
Maybe we should carpool over there.
Maybe we should try to request some temporary
yeah,
parking
I am.
permits.
I'll definitely request parking permits
Okay.
for
But
us.
it's going to be tough, though, I tell you.
Yeah.
Because last time I was there, about a month ago, we couldn't even get any.
The hotel within walking distance
No,
of the
sir.
university? No.
No. Totally
It's really
different.
not a hotel within walking distance.
Yeah, I
they're-
didn't think so.
Some are closer than others, but
Yeah.
Where you got Staybridge is pretty close, but you still had to drive.
I think we're gonna have a van. I mean, that's our expectation. We'll have a rental van, so.
We check with the
larger
school sometime. I
vehicle.
think the school may have a van, couple of van that maybe can come pick up. To take your engineering department, they usually have it.
Yeah, maybe so. So we're gonna start at
I do know,
8:30?
yeah. Yeah. I recommend 8:30.
Okay, 8:30.
Let's fight the traffic.
Anything else?
See, so we're gonna eat at Mr. Thompson's
Edgar Thompson's.
on
Wednesday or
Thursday.
Thursday?
Thursday night, okay.
So Wednesday dinner is on the
Thursday night at the Thompsons, okay. And of course, Friday's the board meeting. We'll start that at 8:30 also. And that's it. I wanna, add anything to this or move anything around?
Casey?
In case y'all are going on this 2016 calendar,
One thing that we might want to do too, John, and we'll shut up after this, see if we got a secondary room to go in case we, instead of all of us being in one room. I don't think that works very well. Gives us another place.
Yeah, okay.
When everybody gets in there for committee meetings, sometimes it gets a little convoluted.
Only when the architects meet that it gets noisy for some reason, seems like. I don't know why that is. All right, the 2016 calendar is on what page is it? 127, right after the October agenda. Just to go ahead and set our meeting dates for next year. Got February 10th through the 12th. At this point, it's after our hearing tomorrow, we're probably not going to have any formals.
We don't have any.
To be scheduled, so.
In the pipeline right now.
I'm still going to reserve that Friday, that third day, potentially for a formal hearing, but.
Yeah, we might have
We
one
might have
in
one.
the coming months, but it's
And new
not
ones could emerge.
immediately gonna happen very soon.
Yeah, but we're not likely to meet that third day. Yes? Yeah, that's right, yeah. Well, I was gonna mention the Surveyors Board has requested that the engineers meet with them prior to our regional meeting, which is April 7th through the 9th. They're meeting on the 6th, so maybe we could have the engineer committee meet with the Surveyors Board on that day prior to the start of our zone meeting here in Nashville. And then,
Yeah.
yeah. And then have the board
Would that
meeting on the
mean you would be
13th.
moving the April 13th through 15th to another
before the zone meeting, or? Oh, you mean to?
I have a conflict April 13th.
No, that's the normal week that we would have it scheduled, but we could move it to a different week. I wouldn't want to do it before the zone
Sorry, I
meeting.
didn't understand what you were saying. I didn't know. Okay.
And now, the June meeting is scheduled earlier than usual because of the CMA Music Festival, which I think begins the following week. So, that's a problem with traffic and hotels. So that's why that's earlier than usual. That's the 1st through the 3rd.
I think the following week, I think, is when Bonnaroo occurs.
All right there
Separated
together.
them, yeah, this next year, yeah.
Got to do it early in June, and August 10th and 12th, and October 5th through the 7th would be the normal time for our planning session and board meeting. We actually moved it a week this year for Laura, yeah. Okay, and then December 7th and 9th, so if y'all are okay with this schedule, I guess y'all could vote to approve.
I move to approve the dates as submitted.
Second.
Any more discussion? All in favor?
Aye.
Aye.
John, you'll send this out with meeting reminders?
Sure.
That works out pretty well.
Yeah, the Outlook
Yeah,
reminders, yeah.
That does work out very well. All right. In-car meeting.
It's on page 128. I know we're running kind of late, so we don't have to go into detail on this, but
Covered at the retreat? Is there anything pressing?
you have a written report, so you can read the written report.
Move to accept the written report.
There you go.
A second.
All in favor?
Aye.
Okay. Well, based on the power vested in me by somebody, we're gonna say this meeting's over.
I make a motion that we adjourn.
Second.
Aye.
We gotta cover some.
Okay.